us his address. This is going to be one of those sessions that is quite interactive. We've got about an hour that has been set aside for us, close to an hour at least, that has been set aside for us to be able to have a dialogue and have conversation. So please do use the chat group. For that, there will be opportunity for you to put questions to the panelists that will also be part of this conversation, and that would be respondents to the address that Inkosi Holomisa is going to give us. On that note, let me hand over to you, Inkosi Holomisa. Please unmute yourself. Thank you.
Okay, thank you very much. Sorry about that. I was saying good morning, Kathy, and thank you for inviting me to this very important meeting. I also want to greet the convener of the conference, Ms. Professor Tulima Donsela, fellow panelists, distinguished participants, ladies and gentlemen. First of all, I thought when people are attending a church conference, especially leadership, they dress accordingly. Would be seeing some collars in the necks of the priests or the imams and so on. Now I see that I'm the only one who is dressed accordingly, dressed for the occasion. That could say something, because we're talking here about customary law and what colonialism and other invasions did to our way of life. And that therefore, when we come, even when we are to talk about our own way of life, the dress code is that of the very same people who descended on our shores and did what they did to us. That is said lightly, but I think it's something we need to ponder on. Nonetheless, Chairperson, it is a privilege for me to have been asked to partake in this pertinent and much needed discourse under the umbrella of customary law, culture, and social justice. Allow me to preface by advancing that to the extent that we are seized with transformative constitutionalism, advanced equality, and other human rights, in customary law, we are deeply saddened and disgusted by the brutal and horrific murder of University of Fort LLB student, Noscelo Mthebeni, at the hands of a boyfriend who, having professed his love for her, was supposed to be a protector and defender. May her soul rest in peace. Unfortunately, she is one of so many who have fallen victim to the wiles of men in our country. This, for me, places into context, impetus, relevance, and urgency of the discussions we're having today in order to make decisive inroads into the psyche and appreciation of the anatomy of customary law, with my topic focusing on separating customary law from colonial and contemporary distortions. Unfortunately, I'm going to disappoint the participants in this conference, because there are so many issues that you would want to raise that have fallen victim to the onslaught of colonialism. 15 minutes, therefore, is not going to be enough. But nonetheless, I am sure with the hour that has been given to this particular session, the question time is going to allow me to elaborate more on some of the issues that people are interested to talk and to listen to me about. In my view, this is an area of research, relatively speaking, that is virgin territory. It is also an area of our discourse that is susceptible to misconceptions, misinterpretations, and obvious distortions. There is paucity of literature that would do justice in depicting the extent of the damage caused by the impact of colonialism and apartheid policies on indigenous South African communities. The notion of structural violence is invariably embedded in our violent political history, in which race, class, gender, and sexuality were normatively constructed. This is courtesy of discriminatory laws that have manifested in institutionalized violence along racial lines over centuries. The migrant labor system, we know, the forced removal of people from their ancestral lands, with the attendant destruction of the family structures, are just some of the cases in point. The apartheid machinery birthed and nurtured an animalistic and violent behavior that culminated in the gender-based violence phenomenon of our time. As a nation living in a democratic South Africa, it is our civic duty to reverse this scourge. Allow me to highlight a few observations drawn from my experience as a traditional leader. Traditional communities in years gone by placed a premium on mutual respect for one another, and paramount was the ability to take care and safeguard one another. Again, the idiom that says it takes a village to raise an African child embraces and validates the notion of a non-violent people exposed to foreign tendencies. The government of the day, willed by the majority of our people, is premised upon an open, democratic, non-racial, non-sexist, and just society. And in this regard, I understand and embrace the wisdom of the human rights leader, Mahatma Gandhi, who famously said, the true measure of any society can be found in how it treats its most vulnerable members. Now, I'm familiar more with the values entrenched yet distorted and abused in African cultures and traditions. I am ordained by the dictates of the cultural values of my father's people to interpret jurisprudentially and administratively how these cultures and traditions are to be implemented. Our culture is about the nurturing, the defense and protection of the weak and the vulnerable. We do not have notions of, for instance, women being perpetual minors. Deliberately or out of ignorance, the colonial invaders, whose legacy we continue to endure, decreed that according to African laws and culture, women were minors. Yet no man of reason regards himself to be superior as to be a dictator in his own homestead. In this regard, for instance, a homestead is referred to as the homestead of Mrs. So-and-so. It is never referred to as Mr. So-and-so's place. Even when we do apply for pieces of land as men for residential and cultivation purposes, we do so because we have a family that we have to provide for. So you cannot entitle customarily to a piece of land for residential purposes when you don't even have a family. What are you going to use that land for? If you don't have a wife, you're not going to have children, you continue to live in your father's and mother's homestead because land is too valuable to be given to anyone who has no consideration of the value of the piece of land because he doesn't really have anything to do with it. It belongs to the community as a collective so that each and every individual in the territory has a piece of land that he can lay claim to as a member of a family. So in these days, where men abuse and exploit women, babies and children, what does it mean to be a man? Being a man means to be none of the things that today's society is complaining about. To be a man is to be a provider to the family. It is to be the guardian and protector of to all who fall within your family. It is to be not a monster, to be feared and as it ravages its daughters and the vulnerable. To be a man is to respect and love your family. One other area of focus and perpetual distortion is the phenomenon of lobolo. The provision of lobolo does not mean the family of the prospective bridegroom is buying the woman as you would when, for instance, you buy a car, a sheep, or a car. She is not your property to deal with as you please. She remains a human being with the same rights as any other person, male or female. She is of flesh and blood as the man, and when she is not in the mood, she must not be forced. Importantly, she is not a servant, not a slave. She deserves respect. Lobolo is meant to form familial bonds between the two families. The cattle themselves normally are contributed by the man's fathers and uncles. By this, they lay claim to the bride, making it clear that they have an interest in her well-being as the new member of the family. The man may not abuse her by beating her up, denying her food and shelter, generally failing to provide for her well-being and that of the children. Lobolo is meant to be a form of safety guard in times of hardship and want, as the woman can resort to her maiden home for support. The cattle deposited at her home are there to support her in times of need. This availability of support is there for her, as well as when she is no longer able to continue to live with her husband or in-laws. The objective here is to create men who will be of value to their families, communities, and the nation at large. The men are therefore meant to be humble, respectful, and productive members of society. At this point, I wish to emphasize that there's no custom that has ever been conceived with the sole purpose of the exploitation and abuse of the vulnerable, least of all women. Any distortion is a negation of the original intent. I have in mind here inter alia the law of inheritance. The heir moves into the shoes of the father, not as the owner of his assets, but as the custodian, whose responsibility it now is to ensure the sustainability of the homestead and the family, to build and grow the family, to feed the family, and to protect its members from the many forms of life. Importantly, the economic and social status of the widow must remain unchanged. There is no basis or justification for her to be deprived of the amenities and benefits to which she was entitled whilst her husband lived. The heir to the family estate is required to provide the support that the father was required to provide to all who depended on him whilst he lived. He is required to keep the homestead and all its possessions in good order and even improve on their quality and quantity. He must conduct rites of passage for his brothers and sisters. He must provide lobolo for the brothers who can't do it by themselves. He must marry off his sisters. In the event that the deceased leaves no sons but daughters, the uncle or male cousin in line who has to take over the responsibilities of the deceased. This again does not mean that he is the owner of the estate. It continues to belong to the deceased and his family members. To do otherwise is to distort the purpose and intent of the practice of the law of succession. Of course, Chairperson, in this day and age, such a responsibility of taking up the management of a deceased estate in the absence of a male heir is limited only to matters of the performance of cultural rituals and assisting the widow and her daughters. Even the registration of the homestead and livestock is done in the name of the widow to ensure the security of tenure and the lawful ownership of movable property. Now, this indicates, therefore, what has been said before, that customary law, customary practices are dynamic. They do not remain in one place. They move with the times. Other customary practices that are oppressive to men are of foreign origin. They are not our own. For instance, the requirement that widows must wear black clothes for a period of a year to mourn their departed husbands is not our own. The practice of widows wearing black clothes was copied from Europeans when they settled in our lands, even though they would only wear them on the day of the funeral. Of course, it is our custom that the widow has to observe a period of mourning for her departed husband, and that the wearing of clothes must be the clothes of modest colors, displaying no style of glamour or in her apparel. I propose the customary practice of Ubutwala. I need to report that the Congress of Traditional Leaders of South Africa, an organization that I 23 years, took a decision long ago to ban that practice. It is no longer necessary for a marriage relationship to be initiated through Ubutwala. Historically, ukuthwala was a legitimate way of expediting the initiation of a marriage by avoiding the drawn-out processes which involved a number of steps and people in negotiations. The practice has since been abused and distorted by a variety of people who have interests that are different to those of the women concerned. Men take advantage of young girls from poor families. They offer goats, sheep, chickens in exchange for the girl's hand in marriage, pretending to be providing the lobola that we earlier spoke about. In such cases, the prospective couple don't even know each other, let alone love each other. The young girls are not even mature enough to be considered women. Such men are criminals who commit the crime of rape and should be treated accordingly. The same goes for relatives who collude in such acts of criminality. They are human traffickers who must be treated as such. So, I wanted to say in conclusion, this topic is, as alluded to, is a rich area of opportunity for further research and interrogation in order to validate and entrench the life lived by rural communities in order to militate against the widespread distortions of the public in the public domain. Now, because I had to limit myself to the amount of time that was given, I didn't say much about, I didn't say anything, in fact, about land, governance by traditional leaders and polygamy. But seeing that I may be having a few minutes, I can touch a little bit on the question of land, polygamy and governance by traditional leaders. Now, on the question of land, as I said earlier, land, tribal land, belongs to the tribe as a collective. It is land that was acquired in most instances through wars with neighboring or other communities. And then that land was then, as I say, occupied by the community. And it has to be used for the benefit of the community. So when we talk about the allocation of land to people who need it, first of all, it must be established by the leadership of the community as to for what purpose is this particular piece of land required. Now, in most cases, as I said, you need the land as a moen because you want to provide shelter for your family and to cultivate food for them as well. Now you go and apply for this piece of land to the traditional leader and his councillors. Then you have to prove that you have a wife or about to have a wife. And then once you have that wife, that land belongs to you and your wife as well as your children and your offspring after that. So it's not a question of it just belonging to the husband alone. If the colonizers had understood our way of life when they came here, in registering the land, they would have registered it in the land of both the husband and the wife, because it is for them jointly. That is why when you have to take another wife in a polygamous arrangement, you provide the same piece of land for her, because you're going to have your own children together with your wife. So they must have that kind of security. On the question of polygamy, well, as I've just said, you don't easily take up more than one wife as a man, unless you are going to be able to provide for them. Because each one provides a homestead for you and herself and your children. So they need to be properly provided for. You are not to take the property of one household and use it for another household when you are not in a position to ensure that the one from which you are taking the property for, like a lobolo cattle, then you are going to impoverish them. You may not impoverish the existing wife by taking on another wife when you are not in a position to provide for both of them. Where somebody has, I beg your pardon?
I'm going to ask you just to begin to wrap up for me so that we can give the other panelists an opportunity to speak and then open up the session, like you said, where you could well have a more opportunity to clarify on some of the issues that you've already set the foundation for.
Okay. Let me wrap up by addressing the question of governance. I think Tuli referred to it. The question of whether the institution of traditional leadership is making the lives of the people under the traditional leadership better now than it was in the past, or vice versa. I would say that given the opportunity and the necessary recognition, a lot of good would have come to the people living in the rural areas, because they would have the advantage of having simultaneously elected leadership and traditional leadership. Traditional leadership has its own attributes of uniting the people, for instance, mobilizing them. It was the traditional leaders who mobilized communities to build schools and clinics during the apartheid years. And as we know that elected leadership is divisive, because there are political parties and politicians who compete, dividing families and communities. And but at the same time, they have the policies that have been formulated by the parties in order to better the lives of the people. So if we had come up with a formula that allows these two systems of governance to coexist, the people living in rural areas would be better off than those who live in the urban areas under poor conditions. Thank you very much.
Thank you. Thank you so much for that, Inkosi Holomisa. And like I said, there will be plenty of opportunity for you to engage on some of the issues that you have already touched on in your address. Of course, you as our delegates, our guests for today, you also have the opportunity of noting some of those questions or reflections within the chat group. Just go ahead and put them up in the chat group. I'm certainly keeping an eye on it so I don't miss any of what you're saying. So let me welcome then the panelists for this plenary session. They're going to give just perhaps their own reflections on the topic that we are discussing right now. Professor Anthony Diala, he's with the Department of Private Law at the University of the Western Cape. He's also the founding director for the Center for Legal Integration in Africa. Professor Diala, the floor is yours.
Good morning, everyone. Thank you for inviting me. I'm going to cut straight to the chase because I don't think 10 minutes is enough to discuss a complex issue as the anatomy of customary law. I'm hoping that even if I'm skeletal in my presentation, that we have more than 50 minutes for discussions. And so then I may be able to expand on some of the points that I'm going to raise. When we speak of the anatomy of customary law, we are essentially asking ourselves one question. What is the legal identity of Africans? To understand this question, we really need to understand the impact of colonialism on Africans. Sometimes we underestimate this impact. We forget the spiritual aspects of colonialism. We forget the economic aspects, the philosophical aspects, the cultural aspects. In other words, everything that has to do with our lives in one way or the other can be attributed to colonialism. I'm going somewhere with this, but I want us to understand, first of all, two motives for colonialism, the colonial experience in Africa. The first motive, of course, is the economic motive. Many of us may be aware that the Europeans, specifically the Western Europeans who came to Africa, did not come here to admire the place. They came to take over. So they came to take over the resources. And for you to take over the resources of a nation or of a people, you would have some sort of superiority attitude and a belief that your own way of life is more superior to the way of life of the people that you're taking over. So sometimes we miss this very important aspect of colonialism. That mental attitude that My way of life is better than your way of life. Therefore, I have the right to impose on you, not just my own laws, but also my religion, my food, my fashion, my economics, my systems of life, basically. So we need to understand that when we speak about the anatomy of customary law and the so-called distortions of customary law, these two things must be kept in mind. The next thing we have to keep in mind is the reaction of Africans to what happened in their lives. In other words, the reaction of Africans to colonialism. Unless we go back to history books, we will not be able to understand because we were not there. But if you read historical works, you'll be able to understand how the initial Africans who met the Europeans, how they received them. They received them with fear, received them with suspicion, received them with curiosity, etc. We will not have enough time to go into what happened in this encounter, but let me simply pick out that there were some Africans who saw colonialism as an opportunity to enhance powers that they did not have. And that's why I like what the Deputy Minister Holomisa said about our attitude and our way of life, even our dressing, etc., and the things that colonialism did to our people. There were African elders who took the opportunity to assert powers that they did not have prior to colonialism. There were people who exploited the new land policies to make changes in the customs of African peoples. That's where the distortion started, the so-called distortion of African customs. What then are we saying about the anatomy of customary law? We are saying that colonialism should be perceived as a historical marker, a sort of line in the sand for the categories of laws we have on the continent. I have identified 3 of these categories, and of course, this is based on fieldwork in West Africa, South Africa, and Eastern Africa. I have identified 3 categories of laws on the continent, excepting religious laws, which I will not mention. The first category is indigenous laws. The second category is statutory laws, also known as state laws. The last category is customary laws. Now, are you surprised to hear that I'm using indigenous laws and I'm also using customary laws? Let me explain why these are 3 different categories. Indigenous laws are the practices, the norms that our forefathers, our ancestors practiced prior to colonialism, as well as the norms and practices that survived the colonial contact. In other words, wherever you find a practice or a norm or a custom that remains in the form it was before colonial authorities came, then that is indigenous law. The clearest example is known as the male primogeniture rule. The male primogeniture rule, for those who don't know, is the rule that the eldest male child will inherit. Now, we don't have enough time to explain why the eldest male child is the only person to inherit, but if I may summarize it, it was because of the agricultural nature of society, the need for defense, for an individual to intercede between the spiritual and the material worlds, a sort of stand as a representative of the ancestors. And so that person inherited the property, not for his own benefit, but for the benefit of the entire family, as the Deputy Minister rightly pointed out. That's the value that underpinned the male primogeniture rule. It is an indigenous practice. But now, whenever you find communities saying, no, that practice is no longer suited to our modern conditions, and therefore, that we want all the children to inherit, irrespective of whether they are male or female, that is customary law. It is no longer indigenous law. I'll tell you why it is customary law. Supposing you find another community that says, no, we shall give it to all the male children, but not the females. The reason, well, for whatever reason, their justification, that is still customary law. It is no longer indigenous law. So therefore, customary law is a mixture of indigenous practices and the influence of colonialism. Today, we have the influence of colonialism. The most prominent influence is the Constitution. Everybody worships the Constitution. We are all idolaters. If I may use that very strong, controversial term, all of us worship the God known as the Constitution. Many people sometimes do not realize that this Constitution is unknown to customary law or unknown to indigenous law. Our forefathers, our ancestors They did not know what the Constitution is, but today we accept the Constitution as the Lord of our legal lives. So this is why I speak about the anatomy of customary law being integral, being crucial to the identity of Africans. Sometimes the most difficult things for people to see are the things staring them right in the face. That's the reality that Africans are facing today. When we speak of decolonization, we talk of Africanization, and yet we promote constitutionalism. I mean, you have to ask yourself this question. Why did our forefathers, the early political liberators, why did they retain the systems left behind by colonialism? Not just in South Africa, but elsewhere in the continent. Why did they not throw them away and start de novo, start afresh? In other words, start with what their ancestors were using before the Europeans came. Why? The answer is simple, because it was impossible to discard. Because colonialism, simply put, in computer language, is the most sophisticated software ever devised on earth. It has self-replicating systems in place. It's sort of cloned, reproduced those Western systems in such a way that Africans themselves will be maintaining those systems left behind by the Europeans. Basically, in the words of Animal Farm, we become the Europeans, but in a different skin. So we apply those systems, we subject customs to values in the Bill of Rights, values in the Constitution that is a stranger, so to speak. In customary law parlance, in indigenous law parlance, the Constitution is the younger brother of indigenous laws because it came after. But we worship the Constitution, we use it, and we fail to appreciate that we are changing our lives in response to the systems put in place by colonialism, from the way we eat, the way we speak, to the clothes we put on, to the way we think, to the laws that we use, the economic systems we have in place, the land practices. Every aspect of our lives have changed and will even change more unless we pause, take stock, and try to capture the spirit, because most indigenous practices, to be frank, are finished. They are gone. They cannot come back. We have changed so many of them. We barely even know them, but they are gone. The only thing left is their spirit. So unless we retain the spirit of indigenous laws, things like Ubuntu, like welfare of the family, like the attendant duty to take care of the family by the eldest male child or whoever inherits, unless we can retain these spirits, what I call the foundational values of indigenous laws, and use them, integrate them into the constitutional values and constitutional spirit and so-called Roman Dutch law, unless we do that, we will end up losing indigenous laws completely. The way it happened in Europe, that's what happened in Europe. When the Romans captured the almighty British, the Britain, the United Kingdom, when they colonized them, they imposed their laws. When the Scandinavians came there, they also imposed their laws on the British. And eventually the British now imposed their own English legal system on us. So we are going to lose indigenous laws entirely unless we preserve their spirit by integrating them with the so-called Roman Dutch law. And so we have a new identity of customary law, and it's left for us to open our eyes and see what that new identity is, and to be able to plot the future of legal orders in South Africa and beyond. I thank you.
Thank you. Thank you so much for that, Professor Diala. I think quite a lot of thought-provocative things that you have said, particularly the distinction that you have given us this morning: indigenous laws, state laws, customary laws. Where do they all intersect? How do we know where one begins and where one ends and where the other begins, given how embedded and how connected and intertwined it has all become? Let me allow then Professor Christa Rutenbach. She is with the Faculty of Law at the Northwest University, and she'll be talking, of course, on the theme for today: customary law in colonial courts. Should the separation of indigenous and colonial laws be the ultimate goal That's the aspect of the conversation that she's going to be addressing. And please continue to put your comments and questions in the chat group. Once Professor Krista is done, we're actually going to then begin with the discussion in earnest. The floor is yours, Prof.
Thank you very much. Can you hear me?
Yes, we can.
Good morning, everyone. It's a tremendous honor and at the same time a daunting experience to say a few words at this important conference on customary law and social justice. To sit around the table of Nkosi Olomisa for a second time after more than 25 years is indeed a privilege. Nkosi, you might not remember, but I was a young academic who was part of the Traditional Authorities Research Team that argued the case of traditional leaders in the Constitutional Court in the certification case in the 1990s. You attended the court proceedings in your traditional attire like today, which made a huge impact on us all. Now, the outcome of the case did not go our way, but what stuck to me is the statement by the court that the text of the new constitution guaranteed the survival of an evolving customary law and that it could not be faulted for leaving the complicated, varied, and ever-evolving developing aspects or specifics of how customary laws should be developed and interpreted to future evolution, legislative deliberation, and judicial interpretation, and I end the quote. Now, it's clear from this statement, and I think we have all seen it over the last 2 decades, that customary law could not escape the winds of change, and it has indeed evolved in many respects, despite some resistance by even more conservative groups and individuals. But most of the changes have been through case law and legislation, and we have no easy way of knowing if those changes have filtered through to the traditional communities. Now, Justice Mohammed, in a speech that he gave many years ago, believed that the influence between common law and customary law worked both ways. He foresaw that both these legal systems will eventually develop into a more integrated system and said that Southern Africa will be poorer without the sound discipline, effectiveness, and historical experience of Roman Dutch law, and will also be poorer without the spiritualizing, humanistic, and bonding values of the customary law. And I end the quote. We are all aware of the success stories of the value of Ubuntu, which has seeped into the legal arena to carve out an undisputed place in the legal literature. But the coexistence of indigenous and colonial laws, and I deliberately use this word colonial to link up with the theme of this panel, have challenges when it comes to the application of customary law in the mainstream courts. I will focus on 3 points that might be controversial. My first point is that customary law and common law cannot be treated equally in the courts because they are not the same. Despite what the Constitution promises and what the court says, common law and customary law are not equal in all respects. The fact that customary law shares the podium with common law does not mean that it applies automatically in any given case. In contrast to common law, which is the general law of South Africa, customary law applies only when it is applicable. Now, despite its equal status, customary law is not a law of general application. It is a personal legal system that applies only to people living under a system of customary law. The qualification, when it is applicable, thus means that in a given circumstance, the court will have to decide whether customary law is applicable or not. This has to be done following the choice of law rules, which are extremely vague at this moment. In 1994, the South African Law Reform Commission pointed out that the courts need to know when they must apply rules from customary or common law, because notwithstanding the recognition of customary law as part of the general law of the land, the circumstances in which it is to be applied are still unclear. This is still the situation. What happens in the courts? In some cases, for example, Marcella versus Khalane in 2000, the court held that the litigant who wishes to have an action determined in terms of customary law must first prove that customary law is applicable. And if it cannot be proven, the common law will apply. Now, my second point is that the courts struggle to find the content of customary law with the common law tools at their disposal. Now, the judiciary takes judicial notice of the common law, which can be found in written sources, such as the Constitution, legislation, precedent, and reliable textbooks. Litigants are therefore generally not allowed to lead evidence to clarify common law rules. Customary law, on the other hand, except for its official version, is essentially an oral law observed by traditional communities, and that is why it is referred to as living law. The fact that living customary law is sought in the community and is therefore flexible has challenged the reasoning of the judiciary on several occasions, and its approach to this problem has not been consistent, particularly the question of whether a court should take judicial notice of living customary law as a question of law or a question of fact. Now, the Law of Evidence Amendment Act, which is still in operation, but has been severely criticized for being a remnant of apartheid legislation, allows judicial notice if customary law can be ascertained readily and with sufficient clarity. Official customary law provides a readily accessible source, and a judicial officer can take judicial notice of it. But what happens in the case of living customary law, which is not readily accessible? Now, earlier court decisions, for example, Duplessi versus Bachatla in 1998, held that a litigant relying on customary law, which is not readily accessible, must prove it by adducing expert evidence to establish it as a fact. So in other words, facts must be placed before the court, from which the court then deduce the customary legal rules. But as some of you might know, in MM versus MN, the Constitutional Court, there the majority held that the determination of customary law is a question of law. And I quote, "A court is obliged to satisfy itself as a matter of law on the context of customary law, and its task in this regard may be more onerous where the customary law rule at stake is a matter of controversy. With the constitutional recognition of customary law, this has become a responsibility of the courts. It is incumbent on our courts to take steps to satisfy themselves as to the content of customary law, and where necessary to evaluate local custom in order to ascertain the content of the relevant legal rule," end quote. Although the court regard customary law as a matter of fact, its words "to evaluate local custom in order to ascertain the content of the relevant legal rule" cause some doubt on the contention. Surely this practice cannot mean anything other than to require factual evidence from which the court can deduce a rule of customary law, which makes it a determination of fact. So it's a playing of words. In this instance, I have to agree with the dissenting judgment of Justice Zontu, who said that customs and usages traditionally observed by any group of people are a question of fact and not of law, and the rules of evidence cannot be bent to accommodate customary law otherwise. It is not fair to expect the courts to bend the rules of evidence to accommodate customary law at all costs, especially at the cost of legal certainty. They are creatures of law that operates within the parameters of the law, of common law, and therefore the rules of evidence should be differently applied when customary law is applicable, and legislative guidance should be provided in this regard. Now, the third and last point I would like to make is the fact that we are quick to assume that colonial courts are ill-fitted to deal with customary law disputes. But if we look at the high number of cases where people take their customary law disputes to the court, it is actually a confirmation of the fact that members of traditional communities are embracing the power of colonial courts to settle their disputes. Now, the judgments inevitably become the origins of customary law rules that are discovered by the court or developed by the court. Is this then piecemeal recording of customary law, which transforms this living law into official law? And then we are back at the original question, what should we prefer, living law or official law? So I don't know the answer, but what I do know is that we cannot continue on the path of keeping the common and customary laws separated at all costs. Cross-pollination has already taken place and will continue to happen. Take the Bear case, for example, where the rule of male primogeniture has been replaced by a statute that contained both typical common law and customary law norms, such as the extension of the meaning of wife and descendant to cater for extended families in customary law. Now, I have used the Poikikos metaphor before to argue that by putting all the different laws in one big pot, letting it simmer and infuse all the ingredients with all the different flavors, we might eventually have a wonderful integrated potjiekos mix, distinctly South African, to be joined by all. So my argument, I think, is more in favor of let us rather have this pollination between the legal systems continues spontaneously than forcing them apart. So thank you for listening.
Professor Rautenbach, thank you so much for those contributions. I'm going to ask all of the panelists from the session, Nkosi Holomisa, I see your camera is on. I'm going to ask Professor Diala to also please switch your camera on so that we are able to continue with the discussion, and easier for me to also gauge who wants to respond to what. So quite a bit then coming out of this session already. Interesting just to hear the takes of all three of our panelists and their approach to the theme for this plenary session. I think that that's actually going to make for a very interesting discussion. Let me first begin by posing this question, and Nkosi Holomisa, this question has come in particularly for you, and it says, I'm curious about the point that you made about how the aspects of custom that are oppressive are of foreign origin. Isn't violence against women a feature of all societies, both in the past and today? Or when you speak of custom, are you speaking to customary ideals which differ from the fact that there are inequalities in families, including violence? And I think just to add on to that, Nkosi Holomisa, just listening to you speak about customary laws and what the original intention was versus the interpretation and implementation that we have in the context of South African society today. Where do we make that distinction? Because what you say versus often what you practiced, seems to be two separate worlds. So where's the disconnect? And do you think that there's a way of actually changing that?
I'm trying to be able to see the questions on my screen. Well, okay. The violence against women is a feature of all societies. I agree with that, because we have the animal in us, where we talk about the elimination, the survival of the fittest and the elimination of the weak. And unfortunately, women are not the fittest in terms of their physical abilities. And therefore, it's easy when you are looking for a person to take advantage of, to direct your energies at women and children. Nonetheless, I don't believe that any man, any father or any brother would deliberately participate in the formulation of practices or laws that are meant to denigrate and undermine women. That's why some of the teachings that are given to the boys who are being turned into men through the initiation ceremonies is that they must be protective of women, protective of children, not take advantage of the vulnerable. Even during wars, even though of course there will always be exceptions, women were spared of the killings that took place. The killing was directed at the male opponents of those who were engaged in war. Unfortunately, this would be distasteful to some. They, together with the cattle and other animals, women were taken over, were captured by the winning army and spared their lives because they were known to be responsible for the perpetuation and the growth of the nation itself. So in such situations, then violence tended to be directed at women, because in any event, even if they're spared, they are taken into a livelihood they never had a choice in. They are forced into marriages and so on, even in those times. But in times of peace, in the absence of war, when there's normality, as I say, these things, these practices that I was talking about are meant to protect the women. Hence, the land that you have that has been given to you as a man is given to you because you have a wife for whom to provide a livelihood and shelter. So, therefore, as I'm saying, the idea is to protect everybody, to ensure that everybody is fine. What's the other question that you raised again? You highlighted?
So I was just adding to the question in terms of the interpretation. When one listens to the presentation that you made about the origins of customary law, and I'm taking that and I'm applying it to the reality of how it is implemented and how it is interpreted in societies, contemporary South Africa, and the disconnect between those interpretations, the disconnect between the implementation. Because even as you're talking about the status of women, that men wouldn't, you don't believe that they would be fathers who would deliberately come up with laws that would denigrate women. The reality is that often women have found themselves in those positions.
Oh, I see. No, I think what my observation in this whole matter is that people live their lives. They are born in a particular lifestyle. So if they are born and grow up in an environment where customary practices are followed, then they follow them. But as I say, they are not in a position to follow them in the same way as they used to before we had influences from outside, influences that became stronger than ours, our ways of life. So these difficulties arise when there are problems, when there has to be interpretation. So for instance, Africans will want to have two weddings. They will want a traditional African wedding, and then they will want, because they believe that this is not quite enough. I am a Christian, or I believe in Western civilization, if you like. So therefore, I must have a white wedding and that kind of thing. It is only when there are problems then that arise difficulties. Because in essence, if you are married in terms of your culture, that marriage is legal, provided all the necessary requirements and conditions have been met. Again, it goes to the question of when is a traditional wedding really, or customary law marriage really concluded. It's really difficult to say, because one might say, well, I provided lobola and it was accepted because I'd come to ask for your hand in marriage, so therefore we were married. And yet somebody else will say, no. The presentation of the lobola kettle was a way of initiating a marriage relationship. There were certain rituals that still had to be performed. We have to be handed over officially, formally, to your in-laws as a woman. Before that you can be considered as truly married. So it's like somebody can say the provision of lobola is just like an engagement. The true consummation of the union or conclusion is when the pen is put to paper that indeed you are now legally married. That is when a certain animal is slaughtered that introduces you to family, and then that receives you and presents you to the ancestors and those kinds of things. So what I'm saying, therefore, I can't say at a particular point, this is when we left our way of life. We haven't. But our own original way of life is overweighed by the received way of life. I don't know if I can proceed to respond to the other points that have been raised.
Oh, all right. I think maybe what I will do is that I want to give Prof. Diala also an opportunity to respond to this issue before you go on, Nkosi Holomisa. And the question then the chat group, Prof. Diala, is about the fact that you agree with Nkosi Holomisa on the colonial influence over customary law, why these distortions, harmful practices that have been distorted, that why it mainly takes place in the direction of women. So why have they targeted specifically women's rights, and men have sought to benefit from those infringements? And the guest goes on to make a couple of examples: ukutwala, genital mutilation, witch killings, succession and inheritance, etc. So basically, the fact that many of these practices are skewed against women. Why is that, Professor Diala?
Okay, thank you. So the reason why we have a quote gender war ongoing now, for millennials who are active on social media, you would know that there's a gender war going on. For example, let me just give personal example from our family chat. One of my sisters said something about the other gender, of course, referring to men. And then she ended up by saying that we fear the other gender. So I now said, we fear you too, thank you. So you can imagine that's a sibling, banter between siblings, but it gives you an idea of this sharp binary between genders that came with colonialism. I say it came with colonialism because I'm not denying that there was gender violence in the past prior to colonialism. But what I'm saying is that we underestimate the impact of the radical socioeconomic changes. In fact, the disruption in the social settings of Africans caused by colonialism. Before colonial rule, Africans lived close together, very close-knit family settings, in a very communitarian sense. Property was produced jointly. Rights and obligations were group-based, and the interest of the clan or the interest of the extended family was the primary, the overriding concern. So the welfare of the family. In that type of setting, there was no sharp binary, gender binary. It was a complementary relationship between the genders, between males and females. The women knew what they had to do. The men knew what they had to do: defend the family, go and hunt. The women farm, care of the. So we did not have all those sharp claims of property rights. There were really no individual property rights in that type of setting. The only matrimonial property that women had were the things that were given to them when they enter a new family as brides. So they're entering a family, they go with their personal items of adornment, and so they go there, that's their personal property, and maybe their kitchen utensils. So when they exit a marriage, mind you, divorce was rare because of all the external influence, the family being heavily involved, both in marriage negotiation and for the stability of the marriage. So divorce was very rare. So in the few cases of divorce, the woman left with her personal items. That formed the customary law that women have no matrimonial property. Whereas in the strict sense, no one really had there was no matrimonial concept of matrimonial property in those days because there was no individual property. Everything was communal. But now we have situations in which people started leaving the family and going to the cities to work. So the concept of a strong, united group production of family production of wealth collapsed. Now we have individual production of wealth, with women earning income individually and contributing to family property. And yet, when the marriage breaks down, some people will claim that, oh, look, according to our customs, women have no matrimonial property and therefore they cannot go with anything. So this gender thing that we have today was the result of colonialism and violence also. Of course, when you know that things to do with money, things to do with emotions breed violence, nobody just wakes up in the morning and without provocation hits the partner and starts assaulting the partner. There are things that build up and lead to it. And these are the little things that we often ignore when we speak about domestic violence.
Nkosi Holomisa? The same question, please. because it was also directed to you, the nature in which it's skewed against women.
Clearly, this is a difficult question. And I thought I tried to respond to it. I did, I think, or I do concede that indeed the way our customary law practices have been followed by those who want to take advantage of them, they have been used in a way that disadvantages women. Nobody bothered to sit down and interrogate each and every one of these practices that have evolved into something like the law. And as such, also when the Constitution itself was formulated, there was a lot of hostility towards the customary law, as well as the practitioners or the implementers of customary law, that is traditional leaders. And they were seen as the people who are perpetuating gender discrimination and oppression against women. And as such, nobody sat down and say the kinds of things that I've been saying. Those of us who were there, or our representatives, defended the position without getting the opportunity to explain as to why exactly are we saying these things, because this would have been an opportunity to, when we formulate policies and laws in the Constitution, we promote the positive aspects of the customary law practices that people were complaining about. So therefore, as somebody asked, can this be reversed now? I think not all is not lost, because a number of people beginning to question, why is it that we accept as a fait accompli that colonial laws are superior and better than ours? It's because in a way they have been explained both by apartheid legislators and current legislators, why it is that we move in a certain way. But when it comes to customary law, there's a lot of uncertainty and confusion, and a person will interpret it from his or her own perspective, informed by his or her own life experience. And as I say myself, this is how, when these matters come before our traditional court here, over which I preside, I interpret them in the manner that I've outlined, so that there is justice and equity in the manner in which people are treated, so that original intent comes out, so that we can move with the times. As I said, for instance, the question of male primogeniture. The person who is the father is the lead of the homestead, and therefore when he passes, somebody must take up that leadership role that the father played. Such same in the same way as the mother is a leader when she has a daughter-in-law married to her son. She has to take over those responsibilities when she's gone as the leader of the house. So the leader, well, it happened that it has to be a male. One of the simplistic reasons is that the male is expected to remain in his original home, while the woman, the daughter, is expected to go and be part of another family after marrying into that family. So therefore, someone has to perform the rituals that the leader of the homestead has to perform. And that will have to be the heir, that in terms of that particular culture is designated to be the heir. There are, as I say, there are rituals, and there are social issues, political issues that have to be dealt with. There are case issues, court cases that have to be attended to by males at the time. Of course, now they are attended to by women as well. So, yeah, it's a matter that requires cool heads, people to sit down. Maybe the chair that Thuli occupies must take this matter up. Well, I remember that she was part of the South African Law Commission that is responsible for formulating laws that are debated and passed in Parliament. So she has to take up this responsibility and ensure that a proper discussion by the decision makers, uninfluenced by political considerations and others, but influenced purely by the need for justice to be accorded to everybody, partly the vulnerable and the weak and the poor. Thank you.
Professor Rautenbach, I just want to check in with you. Any specific comments that you want to reflect on before I continue with some of the questions that have been put through by our delegates?
Thank you. Just a short input from my side. I think we have this romantic view of customary law and how customary law was and how we've distorted it to being what it is now. But we should remember that modernity also always has an influence on laws. So maybe the input this time was colonial laws that came from the West. But if colonial laws didn't come and influence the views of customary law or develop customary law, other influences might probably have developed. Those influences might even came from the inside. As Nkosi Holomisa said, they conquered other lands by means of wars and obtained other lands. So it wasn't all just a happy traditional communities living in South Africa. They were conquering each other. So it was definitely not peace and quiet in South Africa. So it might have gone in another direction. I just think that colonial laws are being made up as the bad guy in this story, but it definitely had positive influences as well that we sometimes do not acknowledge.
All right, thank you for that. In fact, staying then with the issue of colonial laws, Rita is asking, at what point and why did African countries recognize, accept, and adopt colonial laws as superior governing frameworks for African societies and placing such above customary law and practices? And is there any consideration to integrate African laws more and reverse the status quo? So that's one question there. And specifically for you, Professor Christa, when you say you spontaneously infuse the two laws, then pulling apart, I think the Poiki example that you were giving us, a reference to, what do you mean by that? So just unpack that for us. What would an infusion of these two particular laws really look like? And then we'll get into some of the other questions as we continue. So I think probably Professor Diala, let me begin with you. I'll come to Nkosi Holomisa and we'll finish up with Professor Rautenbach.
All right. In response to the question by Rita, colonialism, you have to understand it as a holistic process. So we cannot isolate the various components. There was a spiritual angle, churches were established. There was a philosophical angle, schools were established. It had an economic angle, systems of trade, new systems of commerce, work, etc. were established. There's the political angle, systems of administration were changed. There was the military angle, force was used to conquer communities. There was also the deceptive angle. Communities were deceived into signing away so many of their lands and etc. territories. So the way that colonialism was undertaken made it impossible for African states to go back to what they had before, prior to colonialism. So just to give you an example, Tanzania tried to go back using by starting with making Swahili the national language, making it the language of the parliament and legislation, etc. That did not work out very well. But I think generally African states struggled to to go back to their indigenous practices after colonialism, because the way colonialism was undertaken made it impossible for them to go back. Like I said, it's like a self-sustaining system that, you know, brings people who will propagate the ideas of colonialism, and then they will also raise others in the classrooms and teach them the same new philosophies that they have learned, and so it continued. So we really cannot go back to the past, unfortunately. So that's for that question. I don't know if my colleagues have anything else to say.
Nkosi Holomisa?
Yes, I think to answer the question as to why did or how did African countries come to accept colonial laws as superior governing frameworks of African societies, I think it's a question of them having been defeated in the first place, brainwashed, as Diale says, made to feel that the way of life of the colonizer is better, that the colonizer's form of religion is superior to his own, and his manner of dress is different and better, and the manner of speaking, the language, if he masters the colonizer's language, then he's better than his fellow countrymen and women, and therefore that they became jealous of the power, this lifestyle that the colonizers were leading. And as they are fighting for freedom to liberate themselves and their own people, they are also looking at the seat of power that is occupied by that man who has been oppressing their people for so long. So when they then negotiated freedom at the end of the war between the colonizer and their people, then the framework that has been dominant was that of the colonizer. And therefore, they assumed that this is the way things should go. Now, the result of that is that you find people living in the countryside in most of the African countries, basically having no government. They continue to live under the guidance of their traditional leaders, because the newly elected leaders leave the countryside, go and take up residence and offices in the towns that were occupied and used by the colonizers in order to make sure that they remain dominant. It is only when the election time comes that the politicians will flood the rural areas, paying homage and tributes to traditional leaders, telling them how important they are, how important it is that their people must vote for their political parties, and therefore they recognize them, they are their people themselves, and so on. So the manipulation that occurred in colonial times has survived to the extent that now we don't even realize that, in fact, this is all manipulation. This is not what we had really been fighting for, to replace the oppressor with some of our own. Hence, we continue to experience more poverty and underdevelopment in the rural areas. The people who live in the periphery of the urban areas are flooding into those spaces looking for a better life in the cities, because we continue to neglect the systems of governance, the way of life that obtains in the countryside. So as to whether or not the African laws therefore can be integrated and the status quo reversed, I still believe that as long as there are people who feel that there's justice in the African way of life, even in these times, then the integration could occur. But of course, there's no way I would be living in cloud cuckoo land if I were to say we can go back to the original way of life. That is no longer impossible. And in fact, it's not really desirable in a number of respects, because the lifestyle that it obtains in the urban areas, everybody wants it. But not everybody wants it at the expense of their cultural ways.
Thank you for that. Thank you for that. Professor Rothenbach?
Yes, I do agree. I mean, when the Western powers came to Southern Africa, for example, they did not find a homogeneous, unified state, but what they found were traditional communities spread all over the country with their own traditional authorities. So it was easier for them to come in from a point of power because they were unified and they came with their laws and they started applying those laws. But what we should remember is that, I mean, if we compare our laws now, what I refer to as the common law, this common law is actually made up of many Western laws, Roman Dutch law, English law, legislation. So it's a law common to South Africa. And that's in that context that I use it. That law has developed and adapted to South African needs. So if you compare that, the law that we have now with where it originally came from, it is totally different. So that also changed over the years. If you look at our legal literature from a few years ago, the fight was between Roman Dutch law and English law. So Roman Dutch law initially came and then English influences came, and there was similar struggles saying we should keep Roman Dutch law pure. So it is all debates and struggles going continuously on during the development of law. So when I say we should diffuse or infuse the two legal systems, what I mean is the panel says separating customary law from colonial distortions. But what I am saying is if we focus less on the separation, but more on the infusion or the diffusion of the two laws, we might eventually have something typically South African. So it's a natural development of laws going on, where the fight was initially between English and Roman Dutch law, and the fight is now between customary law and common law, this law that developed. So my argument is that perhaps we should focus less on keeping them apart, but more letting this natural infusion of the two laws continue to see if we can't get something eventually that's not legal pluralism anymore, but allows for diversity. Thank you.
All right, thank you for that. So what I'm going to do, also just being mindful of the time, is that I'm going to just throw what will be a final round of questions to our panelists, so that when you speak, you have the opportunity of addressing just, a couple of questions and also rounding up some of your closing remarks in that. So one question here from Shadi. Shadi wants to know, it's specifically for Prof. Diala. I often grapple with the naming of the legal system, whether it's indigenous law or customary law. From our undergraduate studies, we're taught that laws are developed or created from customs, and as such, a custom practice becomes law. Therefore, is it not mischaracterization of indigenous laws to refer to it as customary law, because these are customs that eventually became law? That's one question there. A couple of questions from Prof. Madonsela. Let me begin with one. This one is for you, Nkosi Holomisa. Do you concede Anthony Diala's point that the distortion of customary law was aided and abetted by traditional leaders, men who wanted to be colonially given power that they never had? In this regard, would you accept that distorted succession law has been abused to the detriment of women and non-firstborn children? Secondly, aren't customary law principles at times resonant and dynamic? Therefore, in modern times, there is no place for a male protector. So if we're to take the example that Prof. Diala gave us earlier of agricultural systems, there are not that many women that you're going to find, at least, not the majority of them who would be in agriculture and making a living in agriculture. Question 2, this is for Prof. Diala. Has indigenous law ever been homogeneous? South Africa, for example, was not a country until 1910. A related point is that sub-Saharan Africans did not fear strangers as Ubuntu saw strangers in terms of the interconnectedness of humanity. And does it make sense to assume all indigenous laws were the same? Is your point not unintentionally romanticizing pre-colonial power relations? And one for Professor Krista, I like the melting pot idea. It has room for mainstreaming Ubuntu, but is it common law? I think you've touched a little bit on that in your last answer, but you can just continue with it further. Let me see. Anthea wants to know, do you think that indigenous law is able to adapt to modern South African society, including the ability to embrace a more empowered position of women today? In my opinion, no law can remain static. Society changes and progresses, hopefully to get better, and all law must adapt with it in order to serve the people in the present day. Let me see a question here from our corner. What would a project on substantive gender equality look like in the context of customary law? Patriarchy is inherent in customary and religious personal laws. How do we transform the power relations based on gender that emanates inherently from personal laws? So I've to just about one question for some of those that have popped questions into our chat box so that you get an opportunity to respond to as many people as possible. What shall we do? Professor Rautenbach, let me perhaps begin with you. Like I said, you can just reflect on those questions that were directed to you or others, and also in the context of giving final remarks.
Thank you. Just short, I think I did give my view on common law already, and that is what I mean when I say common law. I mean it's a law common to South Africa. So it refers to those Western norms that we have in the legal system. So when I usually in my literature distinguish between common law and customary law, and when I refer to customary law, I refer to all the different laws of the communities and also those that are unified, which is the official laws. Just a very short comment on gender equality, such as patriarchy, and the question, what can we do to advance gender equality, especially with in customary law? My comment would be that common law, I mean, is also based on custom. And some of it has been codified by means of legislation. But if you look at the common law, those Roman Dutch law rules and those English influences, they were also custom. And I think that is why it was so easy in post-apartheid South Africa for those laws to adapt to the new South Africa, is because of the fact that not the whole legal system of South Africa was codified. So it would be possible for customary law as well to adapt. And the impetus to do that is the Constitution that provides us with all those values and rights in the Constitution. So it would be able, I mean, we had patriarchy in the common law as well. And so I think 1988, if I'm not mistaken, only then the powers of husbands were taken away from the property of women in a marriage. So if the common law was able to develop and get rid of those inequalities, it would also be possible for customary law to do it as well. And I know that many traditional communities have started with this drive to rid gender inequality from their communities.
Thank you. Nkosi Holomisa?
Thank you. I shall try and respond to some of the questions, particularly by Tuli, where she says that Is it not the case that traditional leaders, in fact, and other men abetted and aided the assault on customary law by colonizers in order to get powers that they do not have? Well, it's possible. You see, the traditional leader is as strong as the community that he leads. If the community or the tribe has been defeated, then the traditional leader is equally defeated. Even in our own intertribal laws, a community that was conquered by another would be taken under the wing of another more powerful traditional leader, and that traditional leader will be allowed a limited autonomy to preside over his community, but under the jurisdiction of that conquering traditional leader. And therefore, he would be forced to, in certain respects, do things in the manner that is required by the one that conquered his people. And therefore, it's possible, therefore, that the colonizers could have, in a number of instances in Africa, used the traditional system in order to achieve its ends. We know that South Africa was balkanized by the apartheid regime in order to ensure that we are not united as African people. Hence, we had there's those many homeland territories that we had. So one has to concede to that. And therefore, it's possible that there could have been powers that they didn't have before, which were given to them, not for purposes of advancing the interests of the people, but to advance the interests of the colonizing power or conquering power. So therefore, it's quite possible. But again, we have to consider that if traditional leaders resisted colonialism and apartheid, a number of them, some of the first inhabitants of Robben Island were traditional leaders themselves, kings and princes of our land. A number of them even died there on Robben Island. And we know not much is being said about that. So others were exiled on St. Helena and other places because they were resisting the colonial project. So others decided, therefore, to be like the reed, the reed in a river, the river bank. When the flood comes, the water comes over them, they bend down. And then when the rains have stopped, then they come up again. But then you find that the big trees, they would be uprooted and taken by the floods and thrown away. And then that's the end of it. So a number of them had to survive, therefore, for the benefit of their own thrones and also for the benefit of the people. Now, the other question relates to the need, really, for male protectors for women. I don't think we want to throw the bathwater with the baby or the baby with the bathwater, because we continue to need the support of our family members in terms of the attributes that they have. Therefore, men currently, they continue to have better opportunities than women, in spite of the fact that we are in a democratic South Africa. But because customary practices evolve. For instance, I spoke about a man being the person who wants to go and apply for a piece of land to the traditional leader because he has to have a wife and children. But the reality is that there are women who set up their own homesteads, not in flats or apartments in town, but in the countryside. They go to the traditional leader naturally with their brother or uncle because they have a family of their own, unmarried as they are, but they have children that they have to look after. So they have to take their rituals, therefore. Once that piece of land has been obtained and the homestead has been established, that need the involvement of male members of the family, of the brothers and uncles and so on, so that they continue to do that. And also, these women will, like anyone who has a homestead, have their own livestock and other property, cars and so on, you need someone there, therefore, who will now and again go and have a look at whether everything is in order in the homestead of so and so. So therefore, it's still necessary, in my view, that there should be that kind of security that is provided by males, because it will be other males again who take advantage of women who live by themselves. Which brings me to the question of omafungwashe, that is the firstborn girl in a family, firstborn daughter, who has a role to play. Yes, indeed, the aunts and sisters to the bride, to the father, they have a role to play, especially when it comes to the settlement and mediation of disputes between family members. Everybody look up to the umafungwashe to come and resolve issues, even if she is living in her own homestead, having been married to other people naturally. So she is required to come. Also for certain rituals, again, have to be done by umafungwashe law, but in essence, the person who continues to lead is the one who is expected to be permanently in that particular homestead. Succession distorted against daughters, succession laws, yes, it could be possible, but as I say, as long as that person who has been designated the heir does not understand that the inheritance that he is at his disposal is not property that belongs to him, there won't be a problem. But if people don't recognize that, including family members and community, that they believe that the person now is in charge because he is in charge and therefore he owns that property, then that's where we lose it. Because as I say, he is merely the custodian of the property that belongs to the real owner of that particular family and homestead. Let me give others a chance, Kev.
Thanks, Nkosi Holomisa. Prof Diala, I'm going to give you literally 2 minutes to try and wrap up for me, because we are running over a little bit and we don't want to eat too much of the next session's time.
Yeah, so I'm going to give rapid fire answers to the questions that we've got here. To C4, yes, African legal philosophy is communitarian, and I've explained that this is because of the close-knit social settings in which customs emerged. For Shadi, I do not conflate indigenous laws with customary law. On the contrary, I distinguish between them. So I define indigenous laws as those pre-colonial norms that people still observe in their ancient forms. And I define customary laws as the adaptations of indigenous customs to socioeconomic changes. By socioeconomic changes here, I mean all those broad philosophical, educational, religious, economic, political changes that came with colonialism. And for those who don't know, colonialism actually is the flagship of globalization. Which brings me nicely to Professor Tuli Madonsela's question about homogeneity in indigenous laws. No, indigenous laws are not homogeneous because of the reality of cultural pluralism. It differs from community to community. They are all very different. So now, question about Africans not fearing strangers. I don't think that's correct. Yeah, we have to really be realistic about the settings in which Africans encountered early Europeans. These are people of a different skin color, speaking different languages. For goodness sake, it might be for us now, if we were to have aliens come from Mars or some other planet, it's the same way that they would receive them. They don't know these people, okay? And the political union known as South Africa was only formed in 1910, but contact between Europe is far, far earlier. I mean, European infiltration or landing on Southern Africa dates back to about 500 years prior to 1910, in the 13th century. So we have to understand that context in which the initial Africans met the Europeans. And of course, the Europeans came with superior weapons, etc. So we are not romanticizing the pre-colonial relations. We're explaining it as it is. It worked for them because that was the setting they found themselves. But then there were then violent disruptions in those settings. Like the Deputy Minister explained, even military conquer of communities forcing traditional leaders to give their loyalty to the new sheriffs in town. Now, about Kaseme's speech on African legal documents, that's an emancipatory speech. Civilization existed in Africa far, far way back, especially in the Egyptian pyramid, the great ruins of Zimbabwe, etc. So there were civilizations that existed on the continent. But the key thing is that by the 18th century, when colonialism really started as a rapidly accelerated, two things happened. Most African kingdoms and civilizations had disintegrated. The second thing that happened, Europe had developed sophisticated weapons, especially the Maxim gun, the machine gun. So technology played a key role in the conquer of African societies. And then finally, can we replace constitutional values with the foundational values of indigenous laws? So the spirit of indigenous laws, can they still be captured? Yes. Actually, that's the focus of the Center for Legal Integration in Africa at the University of the Western Cape. We are looking forward to a future in which we can integrate customary laws with the so-called Roman Dutch law. And the first place to start is by replacing the values in the Bill of Rights with the foundational values of indigenous laws, starting from the judiciary. So a judge wants to decide on something. Instead of the judge to say, okay, let's take the concept of equality, the Western notion of equality. No, rather, let's take Ubuntu, which is an African philosophy. Let's take the welfare of the family, which is an African philosophy. Let's take the involvement of the extended family in marriage, which is an African value. So we take these indigenous values, these foundational values of indigenous law, and replace the values in the Bill of Rights. That's one way to start. And ultimately, South Africa will have a common law of South Africa, which is made up of integrated indigenous laws and the so-called Roman Dutch law. So we have a South African common law in the same way as we have the English common law. But it's not something that will happen overnight, of course. Right, thank you.
Thank you. Thank you so much for that. Let me thank all of the panelists that have been part of this session. For us, it's been really in that keynote address. Professor Anthony Diala, thank you for your contributions. And of course, Professor Christa Rotenbach, thank you for your contributions. It's safe for me to say that you are dismissed, so you can switch your cameras back off. If you can please do that for me, thank you so much. We're going to move on swiftly to the next session. We don't have a moment to spare because we are. So let me not waste any further time and introduce the second plenary for today. And this particular plenary session is going to be focusing on social justice dimensions of land and other property rights. And this is through a customary law lens. So social justice dimensions of land and other property rights through a customary law lens. To give us the keynote address for this particular session, allow me to welcome Advocate Tembeka Ncukai-Tobi. The floor is yours.
Thank you. Thank you for the invitation and the opportunity to speak. I was very interested to listen to the previous session and the fascinating insights that Professor Diale mentioned. So there is a bit of overlap between what I am going to say, although my focus is on land and the enduring distortions of colonial conquest with what he indeed said. I should start with 1846, when the Natal Land Commission produced its report. One of its key members was Theophilus Shapstead. The main focus of the Natal Land Commission report was the establishment of native locations. But at the same time, its focus was on the subordination of customary law to colonial laws. And I take the framework of Professor Diale to distinguish customary law from indigenous law. This is what he said. the natives' own laws are superseded. The restraints which they furnished are removed. The government of their own chiefs is at an end. The Commission proposed a system in which colonial officials could recognize and unrecognize customary practices. Thus began the system in which native laws, customary laws, could continue to exist, provided they were subject to European laws. The outcomes of this report would later be cemented in the Native Administration Act of 1875, which absorbed Africans under the formal legal system of colonial justice. The Zulu Code of Native Law, published in 1878, gave meaning to the 1846 Commission and the 1878 Native Administration Act. This code, euphemistically referred to as the Code of Zulu Law, relegated the status of African chiefs. A chief responsible for a section of an African community was a minor deputy of the Supreme Court, of the Supreme Chief, and a judicial officer. And the Supreme Chief, of course, was the Governor General, a colonial appointee. The Supreme Chief could appoint and dismiss a chief. The code also aligned the function of a chief with the needs of the colonial administration. The role of a minor chief, most of which comprised African chiefs, was to ensure the good conduct of his tribe, the prompt supply of men for the purposes of defense, and to suppress disorder or rebellion, or to supply laborers for public works and the general needs of the colony. Thus, labor and the defense needs of the colony were paramount. The Supreme Chief wielded power to appoint and dismiss chiefs, to compel Africans to provide military service on the part of the colony. New chiefdoms were formed, existing ones were destroyed, and others were combined. While chiefs were generally reduced in status in relation to their administration, in some aspects, the scope of their powers drastically increased. And there were two areas in which there was an expansion of scope of the chiefly power under the 1875 Native Administration Act. It was control over women and control over land. Land could only be allocated by a government-appointed chief. No exception was made for family fields. Women were firmly placed under the control of men as perpetual minors. This is one of the provisions of the Act. The family head, who was always the man, is the owner of all family property in his family home. He has charge, custody, and control of the property attaching to the houses of his several wives, and may in his discretion use the same for his personal wants and necessities, or for general family purposes, or for the entertainment of visitors. Under Section 22 of the Code, the inmates, including women and all children, irrespective of sex or age, shall, in respect of all family matters, be under the control and owe obedience to the family head. This code, together with its two predecessors, were presented as reflective of Zulu custom. Yet, before 1891, women were allowed to be independent of their husbands in cases such as the conclusion of labor contracts, and girls were allowed to marry persons of their choice as provided by law regulating marriage among Africans. As far as property was concerned, it was a definite fallacy that women had no property in Zulu society. A father, for instance, could give property to their daughter, and that became her property. There were instances where a husband could bequeath cattle and other property to a childless wife. Zulu King Cetshwayo Kampande gave evidence commission in 1883 in which he said that women, married or not, could acquire and hold property independently of their husbands, of course, with the exception of land, which could not be held by any one individual. So the changes to the law introduced by the code altered the emerging economic phenomenon of the 1880s and the 1890s of independence among women, who, in some instances, had taken up employment as migrant laborers in the nascent white settler economy. With this changing economic climate, women asserted their independence, challenged the authority of men, and resisted domesticity. These new laws conferring the status of head to men and the authority to inflict corporal punishment constrained any possibility of independent economic and social activity by women. In sum, the power of the chiefs increased considerably in some respects, particularly over land and women. But in its political content, it was drastically reduced. Now, chiefs could no longer administer land according to the wishes of the communities or according to custom, but only under the direction of the colonial magistrate. These changes, known as the Shepstone laws, came to be accepted as Zulu customary law. The Natal Code of Zulu law was no longer seen as an externally imposed system of law, but as a legitimate branch of customary law. The last half century, the last part of the 19th century can therefore be regarded as having laid the seeds of the distortion of customary law. A central attribute of the distortion was to align interests of chiefs with control over land. When the Native Administration Act was passed in 1927, no longer by the Natal government, but by the South African colonial state, its proclamation was that it was intended to apply for the better control and management of Native affairs. Yet, what it did was to continue the distortion that came with the Shepstone laws. These distortions also applied to the ownership and control of land. Not only were these distortions on the political front, there were also distortions on the legal front. While the colonial state had rendered fragile any hold over land by Africans, it would be the courts, the judicial arm of the colonial administration, that would entrench these distortions and make them common sense. Take, for instance, the ruling of the Transvaal Supreme Court in 1902, which held that when Africans were governed by their own customs and laws, the notion of separate ownership in land or of the alienation of land by a chief or anyone else was foreign to their ideas. This was an idea widely held by the judges of the British colonies. Chief Justice Rayner published a report not about South Africa, but about West Africa, Ghana, and Nigeria in 1898, in which he said, the next fact which it is important to bear in mind in order to understand the native land law is the notion of individual ownership is quite foreign to native ideas. My experience in Lagos leads me to the conclusion that except where land has been bought by the present owner, there are very few natives who are individual owners of the land. This indeed would be the same decision in 1910 in the case of Southern Rhodesia, in which the British South African company, everybody knows who they are, this is Cecil John Rose's own company, had acquired land by trickery and force from King Lobengula. When this was challenged, the ruling by Lord Sumner was quite clear. Whoever now owns the unalienated lands, the natives do not. Hence, the land was the property of the Crown, with its minerals assigned to the British Company South Africa of Cecil John Rose. And the final judicial act of empire was a case in Swaziland, Sobhuza versus Alistair Miller and others, where it was held that the notion of individual ownership is foreign to native ideas. Land belongs to the community and not the individual. The title of native community generally takes the form of a usufructuary, a mere qualification of a burden on the radical or final title of whoever is sovereign. Two aspects therefore emerge from the summary of the case law. One is that the colonial judicial arm changed the nature of ownership. But by changing the nature of ownership, it could deny ownership entirely by merely asserting that individual ownership does not exist. It could therefore claim that there is no ownership. And hence, in the final judgment, Sobhuza, the finding could be concluded that ownership belongs to whoever is sovereign. And since the British government was always sovereign, it was the British government that therefore owned the land. But these were also presented as a reflection of the customary system of land ownership. So by the 1950s, the distortion was complete. It began as conquest, it began as war, and it ended as law. Women had no rights to land. Africans had no ownership rights over the land. The Code of Zulu law, which emanated directly from the colonial authorities, was now made as the law of the blacks. Theophilus Shepstein's original vision had come full circle. The foundation had been laid for the stripping of land rights of African communities in the name of customary law. Once the courts accepted the distortions, they simply became common sense. The apartheid state embraced these distortions. It imposed an aggressive system of homelands from 1976 up to 1984. In that system of homelands, the central idea was separate development. And separate development included colonial distortions over the land. With these distortions, we grew up being told that these distortions were part of custom. We grew up with extraordinary powers of chiefs over women, chiefs over children. But what we were never told is that their origins is in conquest itself. The post-democratic state has fared no better. Take, for instance, one of the more controversial laws, the Inguinal Trust Act. While this act enjoyed prominence in the period leading to the 1994 election, it was simply a continuation of the decades of colonial imposition of chiefly authority from above. Look at its key tenets: the stripping of land rights of individuals and family, the concentration of power with chiefs, and the dilution of customary norms, replacing them with Western ideas based on indirect governmental rule. At the heart of this is the idea of trusteeship. The trust land vests in Ingonyama, the king, as trustee on behalf of the members of the community. But look at his powers. They administer the land, they can encumber, they can pledge, they can lease, they can alienate, or otherwise dispose of the land. There is no requirement that the individual residents affected by the decisions should consent, or be consulted. It is sufficient if he consults with other traditional authorities. Even land reform itself cannot take place without consultation with the England. And hence it was inevitable that there would soon be clashes. The king, believing that he is exercising power derived from statute and customary power, began a process 10 years ago to impose leasehold over all individuals living on the property. Prior to that, were given so-called permission to occupy. These were controversial when they were introduced in 1969. Yet they protected the little tenure that Africans had over the land. Africans had no right of individual tenure. And so rights over unsurveyed land were granted through the permission to occupy system, the PTO. But the PTOs were destroyed by the Inguinal Trust some 10 years ago and replaced by leasehold. And this is what led to the clash, and this is now the final point of my talk, which played itself out at the KwaZulu-Natal High Court. The judgment delivered about a month ago promises to herald substantial changes and finally confront Shepstone in the head. These are the findings about the legality of the Ingonyama imposing a leasehold over the land. There are only three that are important for today's topic, which is the social justice dimensions over land through the lens of custom. First finding, this is what the court found in June 2021. As the nominal owner of trust-held land, the Ingonyama does not have exclusive rights to own, control, and regulate trust-held land, nor does it have an unfettered right to deal with such land. It is common cause that the trust and the board in the execution of their functions and exercise of their powers in terms of the Act must act within the parameters of the Act, indigenous laws, and any other applicable law and the Constitution. The key to this passage, it is an extraordinary passage, but the key to this passage is that the conduct of an organ of state, such as the trust, including the conduct of Ingonyama himself, the king, can be tested for validity against the scientific standard of customary law. This is a fundamental transformation of customary law from its colonial and apartheid origin. Customary law now can independently constrain governmental power. When the government acts, not only should it act consistently with the common law or the statute, it must also act consistently with customary law. The second area of transformation that the judgment heralds is apparent from the following quote. The concept that land under Zulu customary law is indivisible and inalienable means that an owner of a particular portion of land cannot take his or her portion and secede from the rest of that particular tribal community, of which he or she is a member, and that the land cannot become a subject of a private sale, as with freehold. It does not follow that as an owner or allottee, one cannot exercise the incidence of ownership in respect of the allotted portion of land to the exclusion of all other members of the community. This statement is important. It shows custom as no longer an appendage of European law, but its antidote. While the common law focuses on exclusion, customary law focuses on inclusion. While the common law is for the individual, customary law is for the community. And thus, the rights to hold land is linked to the interests of the community. One cannot break the community using notions of freehold. One's hold over land is linked to one's membership of a community. And the final quotation from the judgment is the following. Under customary law, each member of each class or community is entitled to an allotment through procedures under customary law. Once a portion of land has been allocated to a particular individual or residential or arable land, it is automatically taken out of the realm of communal ownership. It is demarcated and has fixed boundaries. The ownership thereof descends from generation to generation of such particular individual, owner, or family. However, unallotted and common land is communally owned by all members of a particular community under the administration of an Induna or Inkosi. However, both communal and individually owned land is defended by all members of the community concerned against attack or interference by outsiders. It is only unallocated land which requires prior written consent of a traditional or community authority for it to be encumbered, pledged, leased, or alienated by a trustee. This is the final anti-colonial judicial act. It shows, contrary to the Shapstinian model and contrary to the colonial courts model, that Africans too had ownership. Before a stand is allotted, it is communally owned and controlled. But after allotment, the family acquires rights akin to ownership over the allotted stands. We know this too for those who grow up in the villages. Here, they can exercise rights at the level of umzi. They are protected from external interference. And the larger point is customary law, when properly aligned to the customary values, can provide substantive justice and substantive protections. So customary law has been fundamentally transformed. Yet there are instances in which there is still a clamor to the era of unbridled chiefly powers. Today's social justice challenge is the restoration of not any form of customary law, but a customary law that embeds social justice. Thank you.
Thank you so much for that keynote address, Advocate Ngukai Toby. And just a reminder to everybody that is tuned in, to all the delegates, any particular questions, comments that you want to make, just slot those into the chat group, and we're keeping an eye on it. And yeah, we will of course attend to it once we open the plenary up for discussion. Let me welcome and introduce Professor Almin Duplessi. She's with the Faculty of Law at the Northwest University, and she'll be focusing specifically on the recognition and the protection to customary law rights to fishing, the Constitution, the court case, and the policy-making process. Prof. Duplessis, the floor is yours.
Great, thank you. And good day to all of you. And thank you for the chair for inviting me to speak at this conference on customary law and social justice. So the title of my paper is The Recognition and Protection of Customary Rights to Fish, the Constitution, the Court Case, and Policymaking. The paper focuses on the interaction between litigation and political processes in policy and legislation making, and whether the two speak to one another. In a sense, it looks at the distortion of customary rights post-Constitution. It does so by looking at how fishing policy was developed over the past decades and asking if it really recognizes and protects customary fishing rights within the Constitution's framework. Fish is therefore a resource that I focus on rather than land, and probably more governance than property rights. But I'm not going to go into detail on the constitutional framework. I will only highlight section 39.3, which recognizes customary law as a source of law, and then section 211.3, which is important, that states that courts must apply customary law when law is applicable, but more importantly, subject to the Constitution and legislation that specifically deals with customary law. So that legislation that specifically deals with customary law is what I focus on. Okay, so that was the inquiry, the subject of the inquiry in the Inguinal case, of which the keynote speaker was the counsel. So forgive me if at times I'm a little bit nervous to talk about this case. Nevertheless, the case dealt with communities who has enjoyed customary law rights of access to marine resources in the reserve, it's the Dweza Reserve, for over 3 centuries. During apartheid, the communities were relocated to the land just outside what is now the reserve, and where they still reside to today. They were thus excluded from a significant part of the ancestral land, no longer able to exercise their customary rights in the marine protected area. After the advent of the Constitution, under the Marine Living Resources Act, the Minister of Environmental Affairs and Tourism declared the reserve a strict no-take zone. So this prohibited even members of the community from access to the marine resources. And furthermore, it made it an offense for anyone to fish or attempt to fish in a protected area without permission of the minister. Parallel to this, the community also instituted a claim to have their land returned in terms of the Restitution Act, and a settlement agreement was signed between the community and the Minister of Land Affairs then, in terms of which the land would be restored to the claimants. This agreement, however, excluded the marine protected area, but it did allow for the community to have access to sea and forest resources based upon the principle of sustainable utilization as permitted by law. So the agreement allowed for the community to participate in the management of the nature and forest reserves, and the community was made beneficiaries of ecotourism. But despite this agreement, the ministerial declaration of the reserve as a marine protected area meant that some of the activities has now become criminalized. It is because of this that the applicants in this case were criminally charged in terms of the Act for attempting to fish, entering a wildlife reserve without a permit, carrying weapons, and killing wildlife animals in contravention of the Act. So the appellants pleaded not guilty to the charges, but admitted to contravening the Act. Their plea explanation stated that they were a community and that the community was is still governed by customary law. This system of law regulates, according to them, the use of marine resources, and in terms of the system of the community, they had the right to use the marine resource. When they were therefore arrested, they were exercising their customary rights. Alternatively, they argued if the Act prevented them from exercising their customary law rights, then it is inconsistent with the Constitution and invalid. So it went through the Magistrate Court and the High Court. I will not discuss that due to the interest of time, but it eventually ended up in the Supreme Court of Appeal. The Supreme Court of Appeal found that customary law rights to fish were proved sufficiently. So they were satisfied that the people did show that there's a customary right to fish. But what is more importantly, the court found that only clear and justified extinguishment of customary rights is permissible, which did not happen in this case. So, since the customary law rights survived the decree, the customary right to fish was not extinguished, and the community validly exercised rights in terms of it. That means that they did not contravene the Act, and that the issue of whether the fishing was lawful or not is just not applicable. So the focus here is on legislation that specifically deals with customary law. That is now the focus of asking if legislation replace or amend customary law. Luckily, co-counsel for the community, Michael Bishop, wrote an article on the case setting out a 6-step analysis to determine whether legislation replaces customary law rights or not, and he focuses specifically on this case. I'm just going to mention these steps, as time does not allow us to go into discussion, but I do think it is important to understand how such an inquiry should work. So the steps are as follows. The first question that you should ask is the access to the resource a cultural practice or customary law right? If it is a right, you ask, does legislation specifically deal with customary law? And we will look at what that means. If not, the legislation does not replace customary law rights, and they continue to exist alongside the legislation. But if legislation does specifically deal with customary law, we ask the question, does it extinguish or alter the customary right? If it does not extinguish the right, then actions exercised under it is not unlawful, although it can still be regulated. And then, of course, the other inquiries will look at, does the regulation of the customary right limit other rights in the Bill of Rights? the next step will be if the legislation extinguishes, alters, or limits the exercise of customary law right, is that limitation in line with Section 36 of the Constitution? If it's not justifiable, then it's unconstitutional. And if there is a limitation on customary rights, must customary law be developed in line with Section 39 of the Constitution? So it goes on to say that if what is being infringed is not a right, but a practice, then it can be limited by any law in line with the protections afforded by the Constitution, also most notably Section 36. But for me, the interesting question is, how does this influence policy and legislation? In other words, if the minister now reads this court case, how should she go about making legislation that deals with customary law explicitly if it is needed? First, the requirement is that legislation must deal with customary law expressly or by necessary implication. In other words, the legislature and the executive must inform themselves of the existence of these rights and what they entail. We think of living customary law, and they must expressly deal with that. Moreover, if these rights are protected by Section 30, 31, and 39 of the Constitution, it may only be regulated and thus limited in line with Section 36. If these rights are balanced with something like Section 24, which is the environmental right, it must be scientifically justified, and the interference with customary rights must be as little as possible. So what happened? There was an amendment to the legislation that inserted a new structure that recognizes small-scale fishing, and in that they also recognize customary fishing rights. This makes the MLRA, which is the Marine Living Resources Act, legislation that deals with customary law rights to fish specifically. And it means that it may regulate these rights, but it does not mean that it may do so automatically or that it has extinguished those rights, pre-existing rights. The Act and any action taken in terms of that Act must regulate customary law expressly and then also proportionately. This has two major possible implications. First, customary fishing rights continue to exist and can be lawfully exercised unless or until the minister grants rights and issues permits to a small-scale fishing community. This is only necessary if she believes that the self-regulation of the customary rights is not enough to meet the principles of the Act. Or secondly, the Act should be interpreted as recognizing the pre-existing customary rights while also requiring the recognition of the minister.
So sorry, apologies, apologies for that. I'm not sure where the sound is coming from, but just a quick note to all of our delegates, please make sure your microphones are muted, and maybe the technical team in the if you can just mute wherever that noise may be coming from, and assist us greatly. Thank you so much.
I thought you were stopping me.
No, not at all. And the team at the back end, if you can just please mute one of our delegates there. I think they might not be aware that their microphone is on. All right, Prof. Duplessi, apologies for that. But please do note that your 10 minutes is up though, but I'll leave it there.
Wrap up now, yes, sorry.
No problem.
I timed it to 11 minutes, but let me continue. Okay, so secondly, the Act should be interpreted as recognizing pre-existing customary rights while also requiring the recognition of the minister in the form of a permit before they can exercise the right. This means that the minister does not have a discretion on whether the rights must be recognized or not. She must recognize them, but she can regulate them. However, this is not how the minister and the department understands it. Parallel to the court case, a framework for the recognition and the protection of small-scale fishers was developed, but customary law, with customary fishing law falling into that category. But it's important to remember that not all small-scale fishers fish in terms of customary rights. The amalgamation of the two therefore seems strange, and it cannot be said that that deals specifically with customary rights. Yet the department argues that the amendment provided sufficient recognition, entitling the state to regulate the rights, and in fact means that customary law rights are now extinguished. Members of the community has again been arrested last year for contravening the legislation. Any case, and then what's furthermore, the department also do not regard themselves as bound to the SCA judgment because it dealt, according to them, with different legislation that is now repealed and dealt with the setting aside of a criminal conviction and not the management of fishing resources. So for me, the voices of the people were litigated into the public realm only to be legislated out with regulation of fishing resources, and we are poorer for it. What would have been a better solution? A wholesome solution takes customary law seriously, with the minister appointing an advisory committee on customary fishing rights to establish the existence of these rights of the communities living alongside the coast in order to understand them. To establish a customary right to fish will require that the country must practice and be bound by a general system of customary law that goes beyond the practice of fishing. Within the system, fishing must be a right that belongs to members of that community, to the exclusion of non-members, and the person wanting to claim that right must show that they are a member of the community and that such a right as a member of the community. But for me, the bottom line is that the court made it clear that in the absence of legislation dealing specifically with customary rights, those rights are not extinguished. And dealing specifically means that the department cannot regulate these rights without engaging with the community and getting experts in to help with the rights inquiry. Anything short of this means that they are acting in contravention of the Constitution and that the recognition in Section 39.3 remains a promise on paper waiting for the next court case to be fulfilled. Thank you.
Thank you so much for that, Professor Duplessis. So let me welcome then onto the platform Professor Jackie Dugard, who will be giving us the final presentation for this particular plenary session, and then we'll get straight into the discussions. Professor Dugard is with the School of Law at Wits University, and we'll be talking about transformative constitutionalism, customary law, and mineral rights. How have the courts adjudicated mineral rights related to contestation between customary communities and more powerful interests? So thank you so much, Professor Dugard. The floor is yours. Prof. Duplessis, you can switch your camera off and I will switch them back on again during the plenary session.
Thank you very much. And welcome to everybody. Thank you for participating and thanks to the organizers of the conference. I want, in my research that I'm going to talk about today briefly, to respond to an invitation by Heinz Klug, who recently invited scholars to use transformative constitutionalism as a yardstick to measure the extent to which the constitutional order is being used to disrupt or maintain status quo power. And similarly, Sanele Sibanda has suggested that the standard by which to measure transformative constitutionalism should relate to whether judicial remedies advance or maintain, Sanele Sibanda says, to whether judicial remedies advance disruptive redistribution and reparation to address South Africa's sustained and deepening inequalities. Now, neither Klug nor Sibanda delineate the fault lines of power or relative power, and probably mostly people think classically in terms of racial power in South Africa. But I want to argue that to be truly transformative, it would be necessary to include all axes of relative power, whether economic, socio-political, racial, gender, sexuality, etc. So with this in mind, I've embarked on a project of looking at particular fault lines of contestation and how the courts, as proxies of transformative constitutionalism, how the courts have responded to contestation between more powerful and less powerful groups along a range of axes. And I've looked specifically at how the courts have adjudicated mineral rights contestations across a range of increasingly more complex fault lines in the customary law realm. I've looked at mineral rights because minerals are obviously remain at the center of South Africa's mineral energy complex, and also because minerals as embedded in the land go to the core of one of the most contested issues in post-apartheid South Africa, being property and land distribution and access. So my question really has been, how have the courts fared when adjudicating between quite complex power dynamics to develop the customary law to protect communities from more powerful interests and of various different types? And what I've seen in the customary law realm is that it turns out to be quite complicated and complex about the power differentials. In many of the spaces, you're actually looking at, you have to go beyond a sort of more simple racial transformation lens, because in many of the instances, the power dimensions and power dynamics are not primarily around racial dynamics. There are different types of power differentials at play. So I've looked at 3 cases which focus on 3 different fault lines of power differentials. The first is where you have traditional communities with their traditional leader against a mining company. And in the case of Bengwenyama Minerals versus Genora Resources, it's made even more complex, possibly by the fact that Genora Resources is a Black-owned mining company. So in this case, the traditional community, having received a land claim, wrote to the department to signal its interest in prospecting on the land. Now, it's quite obvious from the case and the papers that there was some dodgy dealings with the department, and the department just simply did nothing about that, and instead allocated the prospecting rights to Genora Resources. But the Constitutional Court ruled in the community's favor, holding that the Minerals and Petroleum Resources Development Act makes provision for a community to obtain a preference right to prospect on community land. So that was a really important case that established that communities, in terms of developing customary law in the mineral rights context, would have a preference claim in terms of prospecting rights by a company. The second case I wanted to look at is where a traditional community actually comes up against its traditional leadership in the context of a mineral rights claim. So this is the Bachatla case, which is a 2015 case from the Constitutional Court. Here, the courts had to decide between the interests of a traditional community, which wanted to establish a communal property association through which to apply for prospecting rights. They came up against the establishment of a trust to be controlled by the tribal authority as represented by the traditional leader, who was Khosi Philani. And in this case, again, the court ruled in the favor of the traditional community and specifically said, we need to transform customary law in line with the Constitution and extend the fruits of democracy to traditional communities still subject to customary law. So that even more complicated fault line case where a traditional community came up against its own traditional leadership in terms of interpretation of which rights would prevail. So what I'm trying to show is these increasingly more disruptive and complex cases that I would say certainly fall into the definition that Sanele Sibanda and Heinz Klug have posed as being transformative adjudication that has developed customary law in a progressive and, you may say, disruptive way against the established interests, however you configure the established interests. And the final case I wanted to quickly discuss is, arguably the most disruptive and revolutionary, I would say, case. And that is the case of Baleni. And this is a 2018 North Gauteng High Court case. Of course, as a High Court case, it could still be appealed, but the government has, although having signaled its intention to appeal, ran out of time, although technically probably they could still attempt to appeal. But as things stand, the case stands. And in this case, what you have is a traditional community versus mining companies, which include an Australian mining company, the South African subsidiary, its BEE local partner, the chief and the government. So you've got a traditional community versus all of those established interests, and all of those established interests want to mine titanium on the community's land, and the community does not want titanium mining, it would like to continue its customary and pastoral way of life, and is very concerned about how titanium mining might destroy that. And in this case, the North Gauteng High Court stresses IPILRA, that's the Interim Protection of Informal Rights Act, protection of communal land rights interests, including the peremptory right to consent to any action that might deprive their land rights. So in other words, what this case does is it establishes that customary or traditional communities have the right to veto mining development on their land. And this indeed gives customary or traditional communities an enhanced right over the common law right, or the right in the Minerals and Petroleum Resources Development Act for common law property owners who would only have the right to be consulted prior to any application for prospecting or mining or mineral rights. Whereas now we understand from the Bachatla case and a prior case called Maledu from the Constitutional Court that customary or traditional communities actually have the right of veto. And this is, I think, is an extraordinarily powerful judgment, and quite certainly incredibly transformative in terms of the court adjudicating on the side of disempowered interests versus very substantially status quo and more powerful interests. So in conclusion, I would say that when called upon to adjudicate between status quo and less status quo interests, the courts have been able to do so transformatively, disrupting the status quo in the interest of protecting traditional community interests in the realm of mineral rights contestation. Thank you.
Thank you so much for that, Professor Dugard. I'm going to ask the panelists from the session to please switch on their cameras. So if you can please just switch on your cameras, and we will begin with the question and answer session to the delegates that are part of today's session. Please pop those questions into the chat box. Let me begin with this one, particularly for Advocate Ngugai Toby. Thank you, Advocate. Very insightful points. I wonder, how would you distinguish between the colonial notion of trusteeship as employed by the Inguinal Trust, its features highlighted by you, versus Communal Property Association Act, born out of a constitutional dispensation insofar as it relates to communal ownership? So we'll kick it off with that one. And the questions, the reflections here by Professor Dugard, and she's posed a question to everyone. So I'll also just put it to the other panelists as well. But let's do that after the first question. Advocate Ngugai Toby.
Yeah, so the colonial trusteeship was a form imposed in order to explain tenure in a context in which ownership was denied by law, and so they imposed trusteeship. Initially, blacks could not even be trustees. The trustees would be a colonially appointed magistrate or a colonially appointed man of the cloth. Most of these were members of the churches, colonial missionaries. And much later, the use of missionaries also declined in scope and importance, and the Native Affairs Commissioner was granted the trusteeship. And when the Native Commissioner system collapsed, the current government stepped into the shoes. But the reason for the introduction of trusteeship is because in a place like the Transvaal, I think a law that was passed by Kruger specifically prohibited Native people or Africans from ownership of land. So that much is clear, that that was its purpose and that was its function. Yet, if you compare, there is no comparison to the Communal Property Association. It's not a trusteeship by any stretch of the imagination. It is ownership. The title is registered in the name of the CPA. The CPA owns it. the individual members have subdivided rights of occupation on the land that is owned by the CPA. Those rights include rights not to be evicted from the land, whereas in the trusteeship system, you actually had no rights not to be evicted from the land. So the two are substantially different. That, of course, does not mean there are no problems with the CPA model. The CPA model simply does not work. That's because there are weak CPAs. There are often competing and overlapping claims over the land. There is often very little income that is derived from the use of the land. And such that in 2013, the government published its annual report on CPAs and actually recommended that the CPA model should be scrapped altogether. This is not surprising. If you lost land in 1913 with a population of 9 million people, you got the land back in 2013 with a population of 58 million. The numbers have grown substantially, and therefore the demands over the land have also increased, but it's still the same piece of ground. It's still the same hectares. There is no surprise that there is such a over the CPAs and that there is even a thought about totally abandoning the CPA model. Thank you.
Thank you. Thank you for that, Advocate Ngugai Toby. Just double checking if any of the other panelists want to weigh in on that particular issue, or if we can just move on. All right. It doesn't look like anybody else is going to weigh in. So I've got a question here, and Jackie was asking, I've been wondering about whether land allocated to families can be regarded as owned by them, or how would one most accurately conceptualize that status as contrasted with unallocated land? All right, I see we've lost Advocate Ngugai Toby. So perhaps Professor Duplessis, let me begin with you, give you a chance to weigh in on that, and then Professor Dugada, I'll come to you as well.
Yes, I see Jackie actually specifically asked Tembeka the question, but I happen to have had the similar conversation yesterday. So those two Wits professors, they in history, I think Breinhardt and the other person's surname I can't remember now, but they actually wrote a book to show how once that land is allocated, it's actually pretty much very similar to our, and yeah, I don't want to look at the customary law through the lens of common law, but just for the sake of answering your question, right, that it is seen as such a strong property right that it's very difficult to actually, you know, not to interfere with it or to lose. So I think that's your question. Sorry. It's regarded as owned, yes. And I think once you are also in communities, a very nice quote that I couldn't get into my presentation, for instance, that the attorney that worked on this fishing case, you know, when they spoke to people and they said, well, do you have rules of what happens if somebody tries and take your fishing rights? And they said, who would like to want to take my fishing rights? You know, they cannot fathom that once you have been allocated this resource, that and within the community setup, that you will actually be deprived of it if all the other customary laws, you know, are functioning optimally. And I think that perhaps answers your questions. It's quite a strong protection as far as I understand it. And I think that's also an argument that they try to make, is to say at least that should be recorded to some extent to ensure that there's a record of it, although it's not registered in the Deeds Registry Act.
All right, I'm going to then take this next question. Is it so common and unjust that Black people are often required to explain why they need their stolen land back, in some instances told that they, Black people, are not farmers, therefore they need not claim the stolen land back? Professor Dugard, let me hand that first over to you, and then Professor Almin will also weigh in.
Sorry, Kathy, I was busy actually responding on the chat, so I missed the question. I apologize. Oh, I see the question. Is it so uncommon and unjust that Black people are often required to explain why they need their stolen land back? So I'm assuming that this is from Rachadi Priska, that they are referring to perhaps the need when you file for restitution of land, the need to prove or to motivate why it's your land and why you need it back. I'm not sure if that's sort of a direct reference to that. And I know that is considered, many people consider that to be pretty unacceptable, that you would have to motivate for being a community that has been dispossessed and for falling under the legislation. But it's hard to know how else one would do it. But having said that, it's totally understandable that it's not a great thing to have to do. But I don't know if Rachadi Priska is meaning it more generally, because of course, as things stand, the restitution process is closed. So I don't know if this is a broader reference to just in discourse, in arguments in politics, and I'm not sure. Of course, I think people should not have to prove why there is a need to bring reparation, restoration, and restitution of land that was dispossessed. But I'm not precisely sure of the context.
Okay, sure. Thank you so much for that. I see Rachadi Priscilla's raising her hand. What I'll do is that I'll ask the team just to please give her access so that she can actually clarify her question and the context of that question. So as soon as she's up, I think we'll be able to unmute her. So the guys at the back end, please, if you can just note that for me. Maybe what will be helpful to do is actually just give her an opportunity to ask that question so that we're able to deal with it holistically and move on. Rachadi, you are on, your hand is being recognized. Please unmute yourself.
Hello, everyone. I hope you can hear me.
Yes, we can. Go for it.
Yeah, so just to clarify, so in most cases when of course, the land debate goes on, but I do find that there's often this question that Black people are not farmers, so why do they have to be given back the land? Which is absurd because, as an example, I often say that one often travels around the country. For example, myself, before lockdown, we would go as a group to go and do road running in different parts of the country. And you find vast pieces of land, for example, in the Magaliesberg area, where young white males often play football, and they've got massive spaces where they are entertaining themselves with bikes and all sorts of things. And then next to it, there's a little piece of land with shacks on top of each other for people to live on. It's absolutely absurd that you find people questioning Black people, what do you need to use the land for? We also want to have big tracts of land to play on, to plant, to eat, to do whatever we like, just like those white young males. Yes?
All right. Rachadi,
Yes,
is that it?
Yes. So what I'm saying is that we just don't need land as Black people to farm and work. We need land for entertainment, to have our children play sports, just like white people are doing right now.
All right, fair enough. I think you've clarified enough. Professor Dugard, I'll begin with you. Go for it.
Sure. Thanks very much for that clarification. I totally understand what you're saying, and I think you are absolutely correct. And I mean, for sure, Almin can probably contribute a lot on this as well. And part of the problem here is that we have a bit of a schizophrenic discourse and also legal framework around land reform generally. So restitution, which, as I was saying previously, that process is technically closed. legally. And that process was never meant to be about, are you a farmer? Can you use the land productively? That was supposed to be about reparation, but that process is closed. So now what you have are land reform programs, which often do require some sort of I know that the minister has often been quoted as, or previous minister, it's hard to keep track, has been quoted as saying, use it or lose it to the beneficiaries of land reform projects. And so we do see a bit of a schizophrenia here in the process of land reform, some of it being about reparation and that door being closed at the moment, and then the only other projects being really about farming, etc. But I think, this does leave the question and the injustices hanging that Rakgadi Priska was speaking about. And as she mentions, nobody goes around asking white people, are you using your land productively? Otherwise, you can't have it. So it's a very problematic area. I think probably Almin has quite a bit to say on that as well.
So I can perhaps start, which is quite interesting whenever I hear this conversation. We had in around 2013, I think, that a draft agricultural bill that wanted to place all rural land under the custodianship of the land of the state, right? And in that bill, they categorized land according to how well it can be used productively for agricultural purposes. And then once the land is in the custodianship of the state will regulate the land use. And if you don't use the land as productive as you can, you would lose the permit, right, to farm. So I think that was the thinking behind that people who have productive land and can use it, for instance, land in the Karoo is not as productive as land, for instance, close to Mooirivier, you need a smaller piece of land to be a productive farmer. So that's an interesting thing. It was taken out the custodianship and those rules. So I'm not sure why, but that might be an interesting place to go and have a look if you want to read more about the conversations we had there. But I think it comes also into what Tembeka said. We had exponential growth in our numbers of people living in South Africa. So it makes it kind of difficult. You come 1994, you sit with the situation, you must have reparations. They choose the 1913 cutoff date. I've just read through the documents where they debated that again the other day. It was sort of a pragmatic decision because going back further, the argument, I think it was of Jeff Bartlander or Derek Hanekom, was that if you go further, you will have overlapping claims and that can, lead to ethnic conflict. Maybe I know there are a lot of people that dispel that notion. So that, those kind of conversations we had already. And then the question, so when you look at having to prove that you lost land, that's the restitution process. You don't need to do that in the redistribution process. But I also understand that in many of the restitution cases, the court did not want to give back the land because they said it's not feasible. So they would say there's a farming operation here and giving it back to the community will not be feasible because the farming operation might no longer run. And I think we can have very interesting questions about that. I do question that. I often have students speak of competence and I'm like, it's not competence, it's productive use. Do we expect that when people get land back that they must only use it productively? Is that the only value that land has? And I think this is the crux of the case. Or does land have other value as well, right? So a lot of other pieces of land, it's got there's a different connection that we have. It's a sense of belonging. It's also, you might want to have land just to have security of tenure. And I think that comes in with that idea that vast pieces of land is open and people are sitting on top of one another. Why can't you give people security of tenure rather without that expectation that it must be used productively? So I think it's a very important conversation to have. What is land important for? But I also think it's just important to note that in terms of the redistribution, we don't have legislation, we only have policies, and it's also not always clear, the policies, but in terms of redistribution, you don't necessarily have to show that you are going to use the land productively. It depends on what land you want to claim. So that's the one thing. And the other thing that I think is a very, very big problem when we talk of land reform, which is not now necessarily a focus on customary law, so I don't want to go too much into that, is that the Department of Housing and the Department of Land Reform are two different departments. So when we talk about land for housing, it falls under a different department in government. And I think there is also a great disconnect that we need to address. But I think that those conversations are happening in the policymaking spheres, but I think it's very important to start asking these questions. What is land important for? Must we expect people to farm productively if they want land back, or is tenure security or a sense of belonging, is that also a valid reason to distribute land?
Professor Duplessis, thank you so much for that. I understand that Advocate Ngcukaitobi is back up on the line, so he'll be able to field of the questions that were directed specifically to him. Advocate Ngcukaitobi, if I can ask you just to switch on your camera and your microphone, the team should be moving you back up onto the panel as well. There we go. We're seeing you now. So one of the questions that Professor Dugard had specifically addressed to you was around the allocation of land to families and whether land allocated to families can be regarded as owned by them, or how one would most accurately conceptualize that status as contrasted with unallocated land.
The judgment in the Case Act versus Inguinal Trust Board says that the land is owned collectively, and the rights of allocatees or allottees are akin to ownership. It itself resists the notion of ownership because it has a common law baggage. But it makes it clear that once land is allocated to a family, it can be passed to children of that family without the consent of the community and without the consent of the chief, which we would regard those who are schooled in the common law as equivalent to the common law. But the debate often has been a contrast between the powers of the state versus the powers of the community, and less so between the powers of the individual family versus the powers of the community. In other words, can the community deprive you of land if they meet and they decide that you should be deprived? The judgment now suggests that it's where the land rights reside, in other words, at umuzi level. And this is, for me, a fascinating development with this judgment, is that the people to be consulted and the people to consent in the case of fresh allotments are at the level of umuzi. Now, why is this crucial? If you try and unpack the people behind the case, it was women who were heading homesteads, women heading the households. In other words, the heads of imizi were women who claimed that it's because of their gender that they are often discriminated in allocation, in evictions, etc. Now, what the benefits are, I mean, if anyone has ever been to a village, one knows that as a matter of practice, most imizi are in fact run by women. De facto and de jure, there are no men. The men are dead, others are in the cities. So the important benefit in allocating the power at the level of umuzi is that it's the woman who is in charge of umuzi that can consent. Now, contrast this with communal decisions. If you actually go to a village meeting and you look there at who the dominant voices are, often it is the man of the village. So we read the case also partly as a gender case. And on that basis, something is to be celebrated. Of course, we must be skeptical. It's early days. It is a new judgment. So the rights at Umuzi level are not ownership rights. There is reluctance to claim that because we are still unsure how to define ownership in customary terms. But there are at least rights to consent, to be consulted, and not to be ejected. And those rights are gender neutral. Any family home and any head of the family, most often the majority are women, is entitled to consent before they can be evicted. And one needs to think about that carefully. In places like Tolobeni, for instance, I mean, the meetings are held, community meetings are held. And the majority does make a decision. The majority should not have the power to deprive tenure at the level of Umuzi. And that is the crucial part of the judgment. I did want to say something about the debate that I reconnected whilst it was going on, which is why should Black people be told what to do with the land? I think that the question depends on what is the land needed for. If we are talking about residential land, I think no one is entitled to tell people what they should do with residential land. But if you are talking about large commercial farms, the public as a whole is interested in their productivity because it is interested in the jobs that the farms sustain. It is interested in the food that is produced by the farms. And because there is employment and there is food production and there is a contribution to the wider economy, the state, I'm not talking about white farmers, the state is interested in the regulation of employment and the productivity. And it is why the state would be entitled to say that if you cannot use a commercial farm, which sustains livelihoods of many, many families, then you should lose it. The Constitution ultimately says the land should be used for the benefit of the public. It constantly uses justice, equity, public interest. Now, what that means is that we should not tolerate a scenario in which people, and often it's not farmers that get this land. If you come to a place like the Eastern Cape, what you get is these are just adjuncts of politicians, just friends of politicians. They get the land, they sit on it. The state should be entitled to take the land so that it can give it to someone who will put it to productive use, because we need the land to produce food and we need the land to produce employment. But that's not the same thing as where you are dealing with it. I think for residential land, nobody should ask you anything about what you are doing it for. The second thing to be said about this point is that nobody asks this question in a restitution context, because the law says as long as you can prove dispossession after the 19th of June, 1913, the land is yours. Or you must get money instead of the land if the land cannot be given back to you. This question is only relevant in a redistribution context. But the question for redistribution is equitable access, which means it's needs-based. So if those needs are present, the land should be taken away and it should be given to someone who can make use of it. And if we did that, we would actually take many pieces from politicians and their adjuncts and give it to actual local farmers who desperately need it to sustain themselves and to sustain their communities. Thank you.
Thank you for that, Advocate Ncukai Toby. Just a comment that I thought would actually be helpful, and I wanted to have the panelists weigh in on it. Sis Mandwa says the conversations are very theoretical and academical with no practical solutions that could be of assistance to amend Section 25 of the Constitution, more especially when it comes to the dissolution of the customary marriages in rural villages in tribal land. So I'm going to give the panelists an opportunity just to weigh in on that particular reflection. Professor Duplessis, I'll begin with you. And if you can respond also in light of you giving final remarks. I see one hand is up. Maybe what I should do is take the hand that's up and allow Sango to actually, oh, is that Nkosi Holomisa? Nkosi Holomisa, I'll give you a chance to ask your questions, and perhaps before they go for the final round of responses. Go for it.
Thank you very much. Actually, I'm not asking a question. I'm just abusing this platform by barging in, because I will be joining the panel, I mean the conference after lunch, the lunch break. But I just wanted to make a comment here, which illustrates a point I made, unfortunately, which is that there's a need for all concerned to sit down and look at our customary law practices and the laws and the laws themselves that are considered as such in terms of our custom. As I sit here, there are people in the other hut here at my home. Fortunately, I'm working from home because of the situation we find ourselves in. I'm going to be having a conversation with them after this, and I'll be telling them about what we're talking about. I'll be telling them that there are landmark judgments that have been handed down by our courts, including the Constitutional Court. And they will be wondering, but why did this have to go that far? Don't people know that you, Nkosi, as our traditional leader, even when we refer to our land, our communal land or tribal land, we say it is your land. We say it because you are in charge of the administration of the land. It is not really yours. It is the land of the clan Amahekebe. So therefore, when you want to do something with our land, you have to consult us as a people. If there's a piece of land that is required for some development or community interest that happens to be owned by a particular family, has been allocated either as Intsini, that is an arable land, or as a homestead, you can't just take it. If it's necessary, the community has to be involved, the family has to be involved, and everybody has to be convinced as to what course of action to be taken. You can't just take it, because the day your great-grandfather allocated that piece of land to that family, it belonged to that family in perpetuity. So therefore, even if it's part of the communal land, but once it is allocated to a family, then it belongs to that family. So you don't have that right, even in terms of our laws. And if the white man's laws that we have inherited give you that power, then that power is legitimately conferred upon you. It is not a power you have. So I thought I should just comment on that, because it shows that our lawmakers, including the constitution makers, I was there at the time, they just had this attitude towards African law and customary practices, that it is basically something that is negative, out of which nothing good can be brought in. Now, the result is that people now who feel that their way of life is under threat under this constitutional order, then they fight back to the extent that they give themselves power they do not have. Because I was appalled when I learned that under the Ngonyama Trust arrangement, now homestead owners, residents or citizens in that area are now no longer the owners of their land. They are tenants, they are tenants in the land of their birth. This land was not fought for by the king of the Zulu alone. It was fought for by AmaZulu under the leadership of the king. Therefore, whatever spoils are found, they belong to the nation or tribe or community as a whole. So I'm saying, therefore, that I am pleased that the points have been made here that the Constitutional Court and other courts have determined in the manner that we've been told. Because in truth, the traditional leader works in council. If he works alone, then then he's going to pass and people are going to revolt. If his council does not represent the true interests of the people they represent in the council, then they are also not following the dictates of customary law. That's why you have a meeting of the council. We have a meeting of what we call Imbizo. That is the assembly, the parliament of the people. That is where the decisions that have been taken by the executive can be reviewed and vetoed and set aside. I thought I should just share that to show that the situation we're in requires that more energy be expended to ensure that we don't have to really waste so much energy to be talking about something that the communities, the ordinary members know is the way things should be going.
Thank you so much for those contributions, Nkosi Holomisa. So looking at the time, we are now officially in a race against time. Professor Duplessis, let me begin with you. Your reflections on the statement that one of our delegates had made earlier, and also just the contributions that have been made by Advocate Holomisa. I'm going to ask the delegates, please, if you can keep your cameras off. Unfortunately, I'm not taking any more questions because we do have a lunch break that we're supposed to be going into now. And so if the panelists, if you can also keep it as brief as possible for me, please.
Great, thanks, Kathy. I'm not sure what the question is of that panelist because you know, amending Section 25, I think we need to have a bigger conversation around what do people expect that amendment of Section 25 to do in the first place. And then also when it comes to the dissolution of the customary marriages. So I'm not sure what the link is there. So I'm just going to skim over it, but I think that links into the language that we use. Sometimes I think we use language for many things, that ownership that Jackie asked about, what did Nkosi said now, the language of the use, that it is the land of the traditional leaders. What do we mean by that? And I think we need more clarity on that, and that we need more engagement. And I think that was also for me the beautiful thing of the Nkosi judgment, where the court said the legislation must specifically deal with customary law. It places a duty on the people that make legislation to go in and engage and to ascertain what that is and what that means before they try to regulate it. Whether the state is capable of doing it, I've been a bit disillusioned the past year in that process, but I'm always going to keep on trying to say you need to go to the people. And yes, the traditional leaders are an important part of that, but that's not enough, because yesterday they had a meeting with traditional leaders along the coast to establish fishing rights, but that's not enough. You need to get the people there that have the rights to try and explain what these rights are. I can perhaps just end off, is Wilmeen Wickham, who was the attorney in the case. She's got this beautiful quote. She said she and Jason Brickhill sat there and they tried, you know, to make a legal argument out of this customary law thing. And they sat there and now they must, you know, get the people to say what they need to say to put in this affidavit. And so they said, how would you describe this right? And this one guy looked at her and said, what do you mean a right? I don't use this language of right. This is a way of life. This is my life. But, you know, if you need to use rights language, or you need to find a right, use that. But I'm just saying this is my way of life. And I think that also is a great, great difficulty of how you will get to, and that I think was also, you know, how do you, when you try to legislate on issues that deal with also things of customary rights, how are we going to overcome that to make sure that the rights are not distorted? Thank you.
Professor Duguid?
Thanks. I would just echo probably what Almin has said, to say that if the question is about Section 25 of the Constitution and expropriation without compensation, I think many of us, if not all of us here on this panel, have argued that that is already possible, that it wasn't necessary to amend the Constitution to achieve that aim. But if the desired aim is, for example, the abolition of private property, then I think certainly some quite wide-scale changes would need to be made. But it's not clear whether people in South Africa generally want abolition of private property. And I think these are some of the debates and discussions that we need to have, that we haven't really had. What property rights do we want? And, you know, it would be even better if we had that conversation before attempting to amend the Constitution, because then we would understand what we wanted to achieve. At the moment, the current bill, the sort of amendment text is really confusing and confused and potentially counterproductive. So there are those concerns. Thanks.
Thank you for that, Advocate Nguka Toby.
Yeah, and I'll just say perhaps three things. I mean, one, I agree with Almin and Jackie about the pervasive confusion around Section 25. We began this in 2018 on the basis that the amendment would target Section 25 2B, which is only the compensation provision. Even that expanded into unwieldy territory. Now there is a reference to state custodianship, but there's complete confusion about what that means. What we know from experience, particularly on restitution claims, certainly what I know from my own clients on the restitution claims, is that they want the restituted land for themselves. They want it to go back to the family that was dispossessed of the rights and land. They don't want that land to go to the state. They are quite clear on that. Even in relation to the redistribution farms, they apply for leasehold for a period of 5 years. But once that leasehold lapses, they apply for ownership. They want to upgrade those rights. And even if you look at the program for upgrading that has been happening in the townships, people want to upgrade these rights for ultimate ownership. So there is still an idea in South Africa that absolute ownership is the holy grail of land reform. So that we can say quite clearly that most individuals who participate in the land reform process do so because they want absolute ownership. There is no evidence that the state has produced that there is a wide-scale desire for state ownership. In other words, to lessen the rights they have so that the land is owned by the state. To be sure, South Africa has had versions of state ownership. In the late 19th century, the Crown was the owner of the land. After 1913, the Governor General became the owner of the land. During the Bantustan era, the trusts, the Transkei Development Trust, the Ciskei Development Trust, the Bophuthatswana Development Trust, became owners of the land. At every stage, Black people have resisted those super ownership structures in favor of a devolved system in which the land is held in their name. And so that's why this idea of state custodianship, which is slotted in at the last minute, is an extremely confusing one and a dangerous one, particularly if it is imposed from the top without genuine popular public participation. I'm not sure if I follow the issue about the abstract nature of the contributions. I think I always try when I speak to make practical examples about cases that I've actually done. So I'm not sure about that criticism. And the last point is to touch on what Nkosi Phathekile Holomisa has said, which I endorse fully, because what he said is a reflection of custom. But in the absence of law, in the absence of a judiciary that intervenes between the powerful and the powerless, what you get is what happened in KwaZulu, in which what he describes to be custom was distorted with the connivance of the government over a people who had no access to legal resources whatsoever. So he says, everyone knows in the village that you cannot make a nominal owner a true owner. You cannot make a true owner a tenant. He says everybody knows that. But 10 years ago, that's precisely what happened in Cape KwaZulu-Natal. The chiefs, including the House of Traditional Leaders, did not speak against this system. Those families in KwaZulu-Natal had to independently solicit legal assistance. Now, what we need is solidarity with the poor. We need solidarity from the chiefs themselves. When one of them acts in the way that happened under the Ingonyam, we need him, Ngosi Olomisa, to say so clearly, openly, and publicly. We do not need to get the judges to intervene at the last stage after 10 years of rent extraction. So I endorse what he says, but the reality is that people on the ground need real solidarity. Thank you.
Colleagues, let me thank you all for being part of the session for today. Up after the lunch break, we'll begin with Judge Mumbi Ngugi. She is the judge of the Appeal Court of Kenya. She'll kick us off at 2 o'clock. Our lunch break has been cut a little bit short by about 10 minutes, but I think it will certainly all be worth it. Well, it has been all worth it. Let me thank you all for your participation, and we'll see each other again at 2 o'clock.